Thank you, Deputy. Good morning, jury members. Please be seated. Members of the jury, I am now going to give you the instructions of law that you need to apply in arriving at your verdict. And you don't need to take notes unless you want to, because each of you will be getting a copy of the instructions. It is your duty to decide the questions of fact in this case. It's my duty to give you the rules of law you must apply in arriving at your verdict. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in this trial, and you must disregard anything you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything that would seem to indicate such an opinion, you are to disregard it. In your determination of the facts, you are not to consider the possible penalties. That consideration is the responsibility of the court exclusively. Your only duty is to determine whether or not the guilt of the defendant has been proved beyond a reasonable doubt, without reference to any possible penalty which may accrue. You must consider these instructions as a whole and regard each instruction in light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. The defendant is presumed innocent of the charge made. This presumption remains with the defendant unless and until the defendant has been proven guilty beyond a reasonable doubt. That the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way as suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. A fact may be proven by either direct or circumstantial evidence or by both. The law does not prefer one form of evidence over the other. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. Attorneys are officers of the court. It is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is, which differs from your recollection of the evidence, You should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the statement. You are the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect. In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case, relationship to the parties, ability and opportunity to know, remember, and relate the facts, manner, age and experience, frankness and sincerity or lack thereof, reasonableness or unreasonableness of the testimony in the light of all the other evidence in the case, any impeachment of the witness's testimony, and any other factors that bear on believability and weight. You should rely in the last analysis upon your own experience, good judgment, and common sense. A witness who has special training, education, or experience in a particular science, occupation, or calling is allowed to express an opinion as to certain facts. In determining the believability and weight to be given such opinion evidence, you may consider the education, training, experience, knowledge, and ability of the witness, the reasons given for the opinion, the sources of the information, factors already given you for evaluating the testimony of any witness. Such opinion evidence is entitled to neither more nor less consideration by you than any other evidence. In determining believability and weight to be given to the testimony of a witness, you may consider evidence of a statement by or conduct of the witness on some prior occasion that is inconsistent with present testimony. Evidence of any prior inconsistent statement or conduct should be considered only to test the believability and weight of the witness's testimony. In the case of the defendant, however, evidence of any statement the defendant may have made may be considered by you for all purposes. In this case, you have heard evidence as to the general character and character or honesty of the defendant. You should consider such evidence with all the other evidence in the case in determining whether or not the prosecution has proven the defendant's guilt beyond a reasonable doubt. During this trial, I have ruled on objections to certain exhibits and testimony. You must not concern yourself with the reasons for these rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which the objection was made, I did not intend to indicate the way to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you to disregard. During the testimony of some witnesses, the parties introduced demonstrative exhibits in the form of charts and summaries. This information was presented to assist you as an aid in your understanding of the witness's testimony and to help explain the facts disclosed by the records, other documents, testimony, and other evidence that was received during the trial. If any chart or summary is not consistent with the facts or figures shown by the evidence in this case, as you may find them, you should disregard the chart or summary and determine the facts from the underlying evidence. Brooklyn Center Police Department policies are not criminal statutes. An alleged violation of a policy is not a crime. In this case, defendant has been charged with 2 offenses. You should consider each offense and the evidence pertaining to it separately and in any order you wish. The fact that you may find the defendant guilty or not guilty as to one of the charged offenses should not control your verdict as to any other offense. If I do not define a word or phrase that is used in these instructions, you should apply the common ordinary meaning of that word or phrase. To cause death, causing the death, or caused the death means that the defendant's acts or act were a substantial causal factor in causing the death of Daunte Wright. The defendant is criminally liable for all the consequences of her actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were a natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not have otherwise occurred. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. The defendant is charged in count 1 with manslaughter in the first degree in connection with the death of Daunte Wright. Under Minnesota law, whoever, while committing a misdemeanor or gross misdemeanor offense, with such force and violence that the death of or great bodily harm to any person was reasonably foreseeable, causes the death of another, is guilty of manslaughter in the first degree. The elements of manslaughter in the first degree while committing a misdemeanor are: first, the death of Daunte Wright must be proven. Second, the defendant caused the death of Daunte Wright. Third, the death of Daunte Wright was caused by the defendant's committing the crime of reckless handling or use of a firearm. There are two elements of reckless handling or use of a firearm. First, the defendant recklessly handled or used a firearm. A person acts recklessly if, under the totality of the circumstances, she commits a conscious or intentional act in connection with the handling or use of a firearm that creates a substantial and unjustifiable risk that she is aware of and disregards. Second, the defendant handled or used the firearm so as to endanger the safety of another person. It is not necessary for the state to prove any intent on the part of the defendant to kill anyone. Fourth, the defendant committed the crime of reckless use or handling of a firearm with such force or violence that the death of another person or great bodily harm to another person was reasonably foreseeable. Fifth, the defendant's act took place on or about April 11, 2021 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. The defendant is charged in count 2 with manslaughter in the second degree in connection with the death of Daunte Wright. Under Minnesota law, whoever by culpable negligence whereby she creates an unreasonable risk and consciously takes a chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the second degree. The elements of manslaughter in the second degree are: first, the death of Daunte Wright must be proven. Second, the defendant caused the death of Daunte Wright by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. It is not necessary for the state to prove any intent on the part of the defendant to kill anyone. Third, the defendant's act took place on or about April 11, 2021 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty. If you find that any element has not been proven beyond a reasonable doubt, the defendant is not guilty. With respect to any alleged use of a firearm, Minnesota law provides that no crime is committed and a police officer's actions are justified only when the police officer uses deadly force in the line of duty when necessary to 1. Protect the police officer or another from apparent death or great bodily harm, 2. Effect the arrest or capture or prevent the escape of a person whom the police officer knows or has reasonable grounds to believe has committed or attempted to commit a felony involving the use or threatened use of deadly force, or 3. Effect the arrest or capture or prevent the escape of a person whom the police officer knows or has reasonable grounds to believe has committed or attempted to commit a felony if the police officer reasonably believes that the person will cause death or great bodily harm if the person's apprehension is delayed. Deadly force means force which the police officer uses with the purpose of causing, or which the police officer should reasonably know creates a substantial risk of causing death or great bodily harm. In determining whether the defendant should reasonably have known that the force she applied created a substantial risk of causing death or great bodily harm, you are not to consider the defendant's underlying intent or motivations. It is not necessary for the state to prove that the defendant intended to cause death or great bodily harm, or believed that such harm would occur. The defendant need only have acted with intent to use force and prove that a reasonable person in the defendant's position would have foreseen a substantial risk of causing death or great bodily harm. As to each count or defense, the kind and degree of force a police officer may lawfully use in protecting themselves or another, effecting arrest or capture, or preventing escape is limited by what a reasonable police officer in the same situation would believe to be necessary. To determine whether or not the actions of the police officer were necessary, you must look at those facts known to the police officer at the precise moment she acted with force. The reasonableness of the particular use of force must be judged from the perspective of a reasonable police officer on the scene, rather than with the benefit of hindsight, taking into consideration the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The defendant is not guilty of a crime if she used deadly force as authorized by law. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of deadly force was not authorized by law. In this case, you have heard testimony about whether the defendant's apparent decision to use a taser was reasonable or appropriate. The statutes of Minnesota provide that a police officer is authorized to use reasonable force in the line of duty in 1. Effecting a lawful arrest, 2. Executing legal process, 3. Enforcing an order of the court, or 4. Executing any other duty imposed upon the officer by law. You are instructed that executing a lawful arrest warrant is a duty imposed on police officers by law. The kind and degree of force a police officer may lawfully use in executing the police officer's duties is limited by what a reasonable police officer in such a situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine whether or not the actions of the police officer were reasonable, you must look at those facts known to the police officer at the moment the police officer acted with force. The reasonableness of the particular use of force must be judged from the perspective of a reasonable police officer on the scene, rather than with the benefit of hindsight, taking into consideration the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. Whether the defendant's apparent decision to use a taser was reasonable or appropriate is not a defense to the charges in this case. Now, members of the jury, I'm going to give you some additional instructions to guide you in your deliberations and with respect to the exhibits. But at this time, the attorneys will be making their final arguments to you. And the state may proceed first.
Thank you, Your Honor. If I may have a moment, Your Honor.
Yes.
Members of the jury, the defendant told you her sons will be home for the holidays. But you know who won't be home for the holidays is Daunte Wright. Daunte Wright's parents, Katie and Aubrey Wright, will have an empty seat at their table this holiday season because the defendant shot and killed him on April 11th of this year. He was just 20 years old. He had a baby boy of his own. And that's why we're here today. We're here because the defendant, Kimberly Potter, a 26-year veteran of the Brooklyn Center Police Department, pulled the wrong weapon, and she shot and killed Daunte Wright. And at the heart of it, this case is very simple, members of the jury. It's a case about the defendant's reckless handling of her firearm, and it's about her culpable negligence. It's about what she did on April 11th. She drew a deadly weapon, she aimed it, she pointed it at Daunte Wright's chest, and she fired. Now, the defense will tell you that Daunte Wright is somehow to blame in causing his own death. But make no mistake, we're here because of the defendant's actions, not Daunte Wright's. She knew she had a loaded gun on her duty belt, a gun that she carried every single day on the job. She carried it on the right side every day for 26 years. And that's the weapon she used. That's the weapon she drew. That's the weapon she pointed. And that's the weapon she fired. Members of the jury, that's culpable negligence, and that's reckless handling of a firearm. resulting in death. This case is about the defendant's rash and reckless conduct. It's not about her being a nice person or a good person. Even nice people have to obey the law. It's not about the smell of marijuana. It's not about a gross misdemeanor warrant. It's not about an order for protection. And it's certainly not about anyone being dragged. No one was dragged. No one was almost dragged. And how do you know that? Well, you know that from what the defendant said herself on April 11th. You know from her own reaction to what she had done, and from what she told you in court. What this case is really about is about an officer who mishandled her firearm. That's why we're here. And even if you take the defendant's word for it, she admits that's what she did. She told you in court she knew it was wrong. And she knew from the very beginning, from the things that she said. She was no rookie. It wasn't her first day on the job. She was an FTO, a field training officer. She had 26 years of experience on the street. Every year, for 26 years, she was trained on how to use her gun and how to use it safely. And every year, for 26 years, she was trained on use of force. And every year, for 19 years, she was trained on using her taser and using that properly. Every year, she saw the PowerPoints. Every year, she was told about the risk of weapon confusion and that pulling a gun instead of a taser could kill somebody. Every year, she signed the paperwork acknowledging the risks. And all that training and all that experience shows she shouldn't have done what she did. All that training and all that experience shows that she was aware of the risks associated with her weapons. She was aware of all kinds of risks. The risk of incapacitating a driver behind the wheel, the risk of collateral injuries, and the risk of drawing and firing a gun instead of a taser. And her conduct and her choices on April 11th show that she disregarded all those risks. Now let's talk about what happened on April 11th and what she did. And the videos show exactly what happened and what she did. This traffic stop on April 11th was nothing out of the ordinary. So ordinary, in fact, that the defendant told you herself she wouldn't have even stopped this car. She wouldn't have even stopped Daunte Wright if she had been alone for the air freshener and the expired tabs. But they did. She and Officer Lucky pulled this car over. And the defendant had initially observed the interaction between Officer Lucky and Daunte Wright. When he first approached, she was hanging out toward the back. She told you it appeared to be a fine conversation. Officer Lucky wasn't in any distress. And then in the squad car, they learn about this ex parte order for protection and a gross misdemeanor warrant. And Sergeant Johnson shows up, and they decide to arrest Daunte Wright on that misdemeanor warrant. Daunte Wright was unarmed. He had no gun. He had no weapon, and he posed no threat to those officers. Now, when they approach together to arrest Daunte Wright, the defendant has her hand on her gun. Now, Sergeant Johnson does not appear to be particularly concerned at all. He puts his hand casually on the car. They approach. She tells Officer Lucky, just have him step out, giving Officer Lucky direction, what to do, how to arrest the driver. Sergeant Johnson and Officer Lucky tell Daunte Wright he's under arrest, and she adds, "You've got a warrant." And when she says that, that's when Daunte Wright pulls away. That's when he tries to get back in the car. Now let's walk through what the videos show. The defendant approaches. She grabs Daunte Wright's right arm with her right hand, uses her left hand to retrieve a piece of paper. This piece of paper, an insurance card. She takes that piece of paper into her left hand and switches it to her right. She reaches for Daunte Wright. She approaches the driver's door from the rear before she would have any view or idea of what Sergeant Johnson is doing on the inside. And you can see, ladies and gentlemen, that Daunte Wright had taken down that air freshener. She approaches from behind Officer Lucky. She moves around him to the left, but still behind him. Now Daunte Wright gets in the car. She's still behind Officer Lucky. And if she even caught a glimpse of Sergeant Johnson in that frame, she wouldn't have gotten a good look at him. She reaches with her left hand for Daunte Wright's left hand with that piece of paper still in her right hand. She's still behind Officer Lucky. She still doesn't have a view of what's going on in front of her. Now, after she reaches for Daunte Wright, she takes that piece of paper from her right hand and switches it back to her left hand. She does this to free up her gun hand, her right hand. Now, 201-55 is the first time that the defendant says, "I'll tase you." She says that, and she's already decided to pull a weapon. And you can see it come into frame at 201-56. She pulls this weapon while looking down at Daunte Wright with this piece of paper in her left hand. She draws that gun. She points it. She holds it in front of her face, looking down at Daunte Wright, pointing this loaded Glock at his chest, aiming it, tracking his movements. Now at 201-58 is the second time she says, "I'll tase you," while still pointing that gun at Daunte Wright, while still tracking his movements, not Sergeant Johnson's. Now at this point, Officer Lucky has had some success in trying to remove Daunte Wright from the vehicle. You can see that Daunte Wright's left leg is out of the car. The defendant continues to point this gun at Daunte Wright's chest. And at 202-00 is when she says, "Taser, taser, taser." And at that point you can see that's when Officer Lucky lets go. And Daunte Wright is able to get both of his feet in the car by the pedals. And at 202 10:01, while she's still saying, "Taser, taser, taser," she presses the trigger and shoots. She shoots Daunte Wright in the chest, and that cartridge casing that you see is circled on the screen ejects right into Officer Lucky's face. It bounces off his face. You can see Officer Lucky's expression after being hit with the cartridge casing in the face as the defendant shoots Daunte Wright under his arm and directly in front of his face. Members of the jury, this may be one of the first frames where you can see Sergeant Johnson. This is Sergeant Johnson as he's backing out of the vehicle after the defendant has already shot Daunte Wright in the chest. You see the top of his head, you don't see his face, and he's backing away after the defendant has already shot Daunte Wright. She shoots him, and she reaches back into the car herself with her left hand, with that Glock still in her right hand. Then she puts it back in her holster. She grabs Daunte Wright's left arm. And she still has that piece of paper in her left hand. Now, not only do you have the defendant's body-worn camera, but you also have Sergeant Johnson's to review. And during that same time frame, let's look at what Sergeant Johnson was doing. He's got his feet on the ground. He approaches the passenger side of the car. He opens the door, again with his feet on the ground. He puts his left hand in at his feet, his shoulders, his hips, his body outside the car, his feet planted firmly on the ground. He reaches over Elena Albrecht Payton, pushes on the shifter so that Daunte Wright can't go anywhere. Sergeant Johnson was clearly not afraid of being dragged. He never said he was scared. He didn't say it then, and he didn't testify to it in court. He puts his hand on Daunte Wright. And is able to pull Daunte Wright's right arm all the way across the passenger side of the car, where he is, outside, almost outside, across the passenger side. He had, at this point, successfully prevented Daunte Wright from driving the car. And he had done that successfully up until the point where the defendant shot him. He was clearly not worried about it at all. And he didn't even remember the line that the defendant fed him. So it clearly was not so significant to him. But after the defendant shoots her gun, and after Sergeant Johnson had chosen to engage and chosen to disengage, he stands up, he steps back, and he shuts the door behind him. Ladies and gentlemen, members of the jury, Sergeant Johnson had the time and the forethought to protect Elena Albrecht Payton from what the defendant had just done. She shot a driver and sent an unguided hazard down the road. The defendant didn't save Sergeant Johnson's life. both Elena Albrecht Payton and Sergeant Johnson were in the line of fire. If anyone saved Sergeant Johnson's life, it was Daunte Wright when he took a bullet to the chest. And you saw Officer Lucky. He was so close that that cartridge casing bounced off his face. That's how close he was. Members of the jury, safe handling of a firearm does not include firing it into a car with 4 people directly in harm's way. In addition to all the other people at risk on that public street, including the Lundgrens, who just happened to be driving by. When it comes to risk, every single traffic stop where an officer pulls over a car and approaches comes with some risk. There's always risk that a driver could take off. Every time an officer reaches into a car or into a window to take a license or hand over a ticket, there's some risk that the driver could take off or flee. There's some risk of being hit by the car, but that doesn't make it an actual threat. It doesn't mean that someone is likely to be dragged, and it doesn't mean that every time an officer approaches a driver, she can shoot them dead. That would be absurd. It would be absurd even if a fellow officer looked scared, which the defendant, mind you, would not have even been in a position to be able to see. Carrying a badge and a gun is not a license to kill. You don't get to shoot someone when things don't go according to plan. I'd like to take a little time to talk about the charges in this case. The judge has given you some instruction. There are 2 charges here: manslaughter in the first degree, manslaughter in the second degree. Here we have a highly experienced, highly trained, 26-year veteran of the police department who drew her gun, who pointed it at Daunte Wright for almost 6 seconds. She pulled the trigger and she shot him in the chest. She did all this all without recognizing or confirming that she had this gun in her hand. And she did those things despite her awareness of all of those risks, all kinds of risks, including the risk of weapon confusion. That's reckless and it's culpably negligent. And these are manslaughter charges, members of the jury. They're not murder charges. They are not intentional crimes. They're not crimes of intentional homicide. No one is saying that the defendant meant to kill Daunte Wright. I'm going to take some time to go over the elements. The judge obviously has instructed you. Some of these things are not so much in dispute, but bear with me. I'm going to take some time to cover what the evidence shows and how that supports each of these counts. So for manslaughter in the first degree, the elements are: 1, the death of Daunte Wright must be proven. Well, that's not really in dispute. Members of the jury, you heard from the paramedics. He was declared dead on scene. 2, the defendant caused the death of Daunte Wright. That's clearly proved as well. You heard from Dr. Jackson. You saw the autopsy photos. You saw the damage to Daunte Wright's heart when that hollow point bullet blew through it. He would have been unconscious within 10 to 15 seconds, and he would have been dead seconds thereafter. And you heard Dr. Jackson tell you the cause of death here was not a vehicle accident, it wasn't marijuana, it was a gunshot wound to the chest. third, and this is the one that I'll spend some time on. The death of Dante Wright was caused by the defendant's committing the crime of reckless handling or use of a firearm. And there are two elements of reckless handling or use of a firearm. First, the defendant recklessly handled or used a firearm. You have a definition of that. A person acts recklessly if under the totality of the circumstances she commits a conscious or intentional act in connection with the handling or use of a firearm that creates a substantial and unjustifiable risk that she is aware of and disregards. Let's talk a little bit about that one for a second. An intentional act or intentional conduct, as you'll see in the later instruction, just means some voluntary act, not a reflex. Some choice you make to act or move your body in a certain way, like putting your hand on a weapon, like putting a piece of paper in your other hand, unholstering a weapon, pulling a weapon, pointing that weapon, pulling the trigger of that weapon. Each and every one of those things, in, of, and by itself, is an intentional act. Let's talk a little bit about substantial risk. Well, pulling, pointing, and shooting a firearm without confirming what it is and what you're doing with it clearly creates a substantial risk of harming someone with that firearm. And she was trained to safely handle that firearm, and she was aware of the risk of killing someone with that firearm. Members of the jury, she told you herself, I could kill someone if she ever used that firearm. She disregarded that risk. And her actions show that she recklessly handled that firearm. In pulling that gun with her finger on the trigger, pointing it and aiming it at Dante Wright's chest, pulling the trigger, shooting into the car. Her statements also show you she has an awareness of that risk. So what else did she tell you? She told you last week that she wouldn't unsnap her gun holster on the way to a car because she's only 5'3" and she could lose it in a fight. Whether or not you believe that to be the case, whether or not she actually unsnapped her holster on the way to the car, doesn't really matter. What matters is that she acknowledges that she knows that she carries a gun on her hip every day and that there are risks associated with even carrying that gun, let alone using it. She knows it's dangerous. It's dangerous to use, and it's dangerous to lose. And she admitted that. It's obvious. It's a deadly weapon. You can use your common sense. But it also shows her awareness of the risks of that firearm ever being taken out of the holster at all, by herself or anyone else. It's a loaded Glock with a round in the chamber and no external safety. Now, in addition to that risk, officers are warned about that risk of what they call weapon confusion, pulling and firing the wrong weapon. You heard, members of the jury, that weapon confusion is well known in the entire policing industry. It's warned about in trainings, it's talked about in policies, and it was known by the defendant. She was in the classes, and she told you she paid attention. She was aware of the risks of pulling her gun instead of her taser and shooting someone. And she disregarded those risks. Blindly pulling any weapon out of your duty belt while knowing that you're armed with a loaded gun every day is reckless. and it's consciously taking that risk. And you heard that even former Police Chief Gannon acknowledges, yeah, officers should know when they have their gun in their hand. Let's talk about this second part of the reckless handling instruction. The defendant handled or used the firearm so as to endanger the safety of another person. Well, drawing a firearm, pointing it at someone's chest, pulling the trigger, all of that is clearly dangerous. It was dangerous to Daunte Wright, and it was so dangerous that it in fact killed him. It was also dangerous to everyone around him. To Elena Albrecht Payton, to Officer Lucky, to Sergeant Johnson as well, who were all potentially in harm's way. Fourth, the defendant committed the crime of reckless use or handling of a firearm with such force or violence that the death of another person or great bodily harm to another person was reasonably foreseeable. If you draw the gun, your gun, and point the trigger, or if you point the gun and pull the trigger, it's clearly foreseeable that you can hurt or kill somebody. And that's actually what happened here. And the defendant herself told you that over the course of her 26-year career, she never fired her weapon in real life because she knew that I might kill somebody. So what does that show? It shows awareness of a foreseeable risk. It's clearly foreseeable that you can kill someone when you mishandle your firearm and pull the trigger. And it was foreseeable to her. Fifth, the Defendant's Act took place on or about April 11th, 2021 in Hennepin County. That's not really in dispute. Brooklyn Center is in Hennepin County. All of this happened on April 11th. But I'd also like to point out, as I said before, that it is not necessary for the state to prove any intent on the part of the defendant to kill anyone. We don't have to prove it. That's not what this case is about. Let's talk about manslaughter in the second degree. The death of Daunte Wright must be proven. That's the same. I'll come back to the second element. The Defendant's Act took place on or about April 11th in Hennepin County. That's the same too. But let's talk a little bit about the second element in culpable negligence. The defendant caused the death of Daunte Wright by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. And then culpable negligence is defined for you. Intentional conduct, that's the same thing that we talked about before. Voluntary act, not a reflex. That the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Members of the jury, she made no effort to protect against shooting and killing someone. And she took specific actions that put Daunte Wright and everyone else around him at risk. An ordinary and prudent person would not have drawn a weapon, held it for more than 5 to 6 seconds, aimed it, and pulled the trigger, all without recognizing or confirming what was in their hand. The defendant created an unreasonable risk of harm to Daunte Wright and everyone else around him by doing what she did. Her actions created the risk. She put that into motion. She didn't have to intend to harm anyone. She didn't have to intend to kill Daunte Wright. But that's what she did. She consciously took a chance of causing death or great bodily harm by pulling a weapon and firing it without giving it a second thought. She knew she had a loaded Glock on her duty belt, loaded with hollow point rounds, a gun with no external safety, like we discussed, and all you had to do was pull the trigger. Not only did that have a strong probability of hurting or injuring someone, she actually killed someone. Responsible gun owners know to secure their firearms, to lock them up, to keep them safe, to store them securely. Responsible gun owners know the importance of safely handling and using their firearms. They're dangerous. You gotta be safe. Responsible officers know not to blindly draw their weapons and press the trigger. And responsible officers are acutely aware of the risks of getting it wrong. Members of the jury, we're here because this was entirely preventable, totally avoidable. If she had followed her training and paid attention to what she was doing and considered the risk. And she was aware of the risk. She appreciated the risk. And what's the best evidence of that? Her own admissions. What she said afterward, what she said in court. But on April 11th, she said, "I shot him. I pulled the wrong fucking gun. I'm going to prison. I killed a boy." Let's talk a little bit about deadly force. You have a long instruction on this, but I just wanted to touch on it briefly. Deadly force is the force that was used here. It's the force that was used when the defendant shot Daunte Wright with her gun. Even if she didn't intend to use deadly force, she intended to use force. And that's clear from what she said and from what she did. And a reasonable person in her position would have foreseen a substantial risk, again, of death or great bodily harm from her actions. Reasonable people know that guns kill. And if you pull one and press the trigger, people can die. You don't blindly pull weapons and pull the trigger without being aware of that risk. That's common sense. So as far as this instruction, the defendant need only have acted with intent to use force, so even if she just intended to use a taser, and prove that a reasonable person in the defendant's position would have foreseen a substantial risk of causing death or great bodily harm. We just discussed that. And as to each count or defense, the kind and degree of force a police officer may lawfully use in protecting themselves or another, effecting arrest or capture, or preventing escape is limited by what a reasonable police officer in the same situation would believe to be necessary. When you're arresting someone, you still have to act reasonably. A reasonable police officer would not believe it to be necessary to use deadly force in these circumstances. What do reasonable officers believe? Well, they believe they shouldn't use unnecessary force. And here, deadly force was entirely unnecessary. And if you look at what Sergeant Johnson and Officer Lucky did before the defendant stepped in, they were using a proportional amount of force to address the situation. And even the defendant herself acknowledges what they were trying to do. They were just trying to stop him from getting away. They were not responding to any real threat. And how do you know that, members of the jury? It's evidenced by the videos. The last line that's highlighted here is to determine whether or not the actions of the police officer were necessary, you must look at those facts known to the police officer at the precise moment she acted with force. go back to the videos, members of the jury. You can see what happened and what the defendant would have actually been able to see. But even when she testified before you, the defendant herself acknowledged that she didn't think deadly force was appropriate. She acknowledged it was unreasonable. And she acknowledged that shooting him was not warranted. But that's exactly what she did. That's the force she used. She used deadly force. She put a bullet through his heart. She killed him. And her statements are admissions that establish that she was reckless and culpably negligent in using deadly force against Daunte Wright. Because she knew it was unreasonable, and she knew it was unwarranted, and she did it anyway. She put it all in motion despite all the risks. It's her hand, it's her gun, it's her actions. Members of the jury, you also have an instruction on non-deadly force. That's not really an issue when it comes to the charges in this case. It's not the force that was used here, and you'll see that it's not a defense to the crimes that are charged. And that's what's highlighted at the bottom. But on the topic of the taser, it's worth noting that you heard from Seth Stoughton, and he had pointed out that even if she had used a taser, it would have been inappropriate under the circumstances. Where she could, and ultimately did, disable the driver of a vehicle, and which could, and ultimately did, injure other people, like Elena Albrecht Payton, like the Lundgrens. That's why those policies exist, members of the jury. That's why you don't tase a fleeing suspect. That's why you don't tase the driver of a vehicle. So what's the point of all that evidence about proper use of a taser? Well, it goes to show that even the decision to use a taser was not a wise one. It goes to show that she made a series of bad choices that led to her shooting and killing Daunte Wright. It goes to her disregard of all the risks. Members of the jury, this was no little oopsie. This was not putting the wrong date on a check. This was not entering the wrong password somewhere. This was a colossal screw-up. A blunder of epic proportions. It was precisely the thing she had been warned about for years, and she was trained to prevent it. It was irreversible, and it was fatal. Members of the jury, the people involved in this case happen to be the defendant's police family, is what she called them. The people who knew the defendant well, who know her well. Some have worked with her for years and years and years. Some have grown very, very close to her, including her own direct supervisor, who was Sergeant Johnson, whom she referred to as a rock star. When trouble comes, it's family that supports you unconditionally. Sticking by each other, for better or for worse, is what makes family family. The same thing appears to apply to the defendant's police family. The defendant has found herself in trouble, and her police family has her back. The state doesn't get to choose who the witnesses to a crime will be. But relationships to the parties is something you can consider it's in your instructions when evaluating the testimony of any witness. And like with any family, often the clearest, most objective view comes from outside that family unit. An unbiased, reasonable, outside perspective. Outside the emotional bonds that tie family together. Keep in mind, members of the jury, that Commander Grunig and former Chief Gannon, they brought in the BCA to investigate this case, to make sure there was an independent review of what happened on April 11th and what the defendant did. Why do that? To avoid conflicts of interest, to avoid bias, to ensure independence and transparency. You saw for yourselves why. How can we ask officers who've known and liked the defendant, Kimberly Potter, for years, and who have been a part of her police family for decades, how can we ask them to independently assess what happened on April 11th? Self-review doesn't always work, and your common sense will tell you that. And I'm sure most Brooklyn Center police officers would have preferred to not have to be here to testify before you, but they did, and they had to. But the further away you get from the bias of a close relationship with the defendant, other officers, if you look at experts like Seth Stoughton, and even the defense experts, the clearer things become, the farther you move away from outside that family unit. You as jurors are in the best position to evaluate the evidence independently, without prejudice and without bias, to any party. You're not beholden to the police department, you're not beholden to the defendant, and you're sure not beholden to the state of Minnesota. Your job is to fairly and impartially consider the evidence and the charges in front of you. That is all we're asking you to do here. And like I said earlier, this case is pretty simple. It's about the defendant's reckless handling of a firearm, and her culpable negligence. It's about what she did. It's about her killing Dante Wright. And what happened in this case is captured on video, and you're entitled to rely on your common sense. Don't speculate. Don't get sucked down that rabbit hole of hypotheticals and misdirection. What ifs and could haves are not the law, and none of that changes what actually happened here. What the lawyers say is not evidence. And you have an instruction on that. Even if we bang on the table and yell and stomp our feet, still not evidence. And anything we say doesn't change what actually happened in this case. Your job is to look at the evidence, to use your common sense, and apply the law. And how are you going to do that? You can do that any way you like. You're the jury. But the videos are an important part. You can go back to the videos. You can play them. You can rewind them. You can pause them. There are several videos you can review. And you'll have them on a laptop with all the other exhibits in this case. You'll also have the gun and the taser back there when you deliberate. They will be made safe for you, of course. The ammunition will be separate from the gun, but you'll be able to hold the taser and hold that firearm to compare those features to get a feel for the two and to get a sense of all those differences that you heard about in court and see for yourselves how different they really are. And you'll also have those exhibits that are the training materials and the policies. And why are those policies important? Well, of course, a violation of policy in, of, and by itself is not a violation of law. You have an instruction on that. But the policies are important because they show what the standard of practice is, what the officers are expected to do as part of their jobs, what they're expected to know, what they're expected to do and not do. They include the things to consider in deciding to use force and how much force to use. And importantly, they show that the police industry as a whole has been aware of and has taken all kinds of steps to address and prevent things like weapons confusion for decades. There are a lot of policies. You'll have a lot of documents. There's also one that includes language about spark testing. Why is the spark test important for a taser? Members of the jury, spark tests are important because they rebut any claim by the defendant that she spends more time using her gun than her taser. The point of a spark test is not only to check to see that it's working, to make sure your taser is functional, but it's also to put your hands on it. It means you have to pull it out, hold it in your hand, put your finger on the trigger, and test fire it every day you work, before every shift. That's the expectation. That means that every Brooklyn Center police officer should have their hands on that taser every day on the job. Every day she was supposed to practice using that taser. Now, the defense may refer to this as an unfortunate mistake or a tragic accident, or that because the defendant didn't know or didn't realize that she had a gun in her hand, that this is somehow an accident and not a crime. That is simply not the case. It's just plain wrong. Accidents can still be crimes if they occur as the result of recklessness or culpable negligence. You're not going to find the word accident or mistake or error anywhere in your jury instructions because it's not a defense to the crimes charged. An accidental killing is still a crime if the defendant's actions are reckless or culpably negligent. And the defendant's failure to recognize she was drawing and handling and firing her gun, despite hours and hours of training, despite years and years of experience, despite the clear differences between the two, and despite the opportunity to change course and correct, and despite all the warnings and cautions against doing this very thing, is part of what establishes the defendant's recklessness and culpable negligence in killing Daunte Wright. On the subject of errors or mistakes, you heard from Dr. Miller that action errors that we sometimes see are those things like misdating a check or entering the wrong password. And as I said, members of the jury, drawing and firing the wrong weapon is not the same as misdating a check. And doing something for 26 years does not automatically override another thing you've done for 19 years. There was a lot of discussion from Dr. Miller about the medical field, the field of aviation, and how errors can happen. But anyone can be prosecuted for their criminal negligence. Anyone can be prosecuted for reckless driving or child endangerment. And anyone can be prosecuted for reckless handling of a firearm. The same applies to police officers, just like anyone else. But people who do the job right should not be judged by those who do it wrong. And this case is about only one person's conduct. It's about the defendant's actions in killing Daunte Wright. It's about her recklessness. It's about her culpable negligence. The professional world is based on the principle that instruction and training and practice and prevention, that those things work. And that people have to be responsible for following their training and being aware of risks. That's what training's for. You can rely on your common sense. Training works. Human nature did not kill Daunte Wright. The defendant did. The defendant told Dr. Miller, "I don't make mistakes. Take that for what you will." She also told him that the car was running. The car was on. So she knew she was firing on the driver of a vehicle, which makes any decision to use the taser even more dangerous and more risky. She also told Dr. Miller that Officer Lucky and Sergeant Johnson backed away. They disengaged when she said taser, taser, taser. So apparently, that's all it took to call them off. And once they backed away, there would have been zero risk of anyone being dragged. There would have been no need to fire any weapon at all, no matter what she may or may not have initially perceived. In this case, and in her career, the defendant consciously and intentionally took on a very important and very serious responsibility. She chose to become a police officer. And she failed in that responsibility. She betrayed her badge, and she betrayed her oath. She betrayed Daunte Wright and her fellow officers too. And her conduct was criminal. This case is not about Daunte Wright. Daunte Wright is not on trial. He's not the reason we're here today. So whether or not you agree with his decision to flee is not what this case is about. He's not the defendant here. This case is about Kimberly Potter. We're here today because of her conduct, her choices, and her actions. We're here today because she killed Daunte Wright. But this case is also not about the defendant's law-abiding or peaceful nature that you heard about. It's about what she did on that day, on April 11th. It's about her rash and reckless conduct. You heard from a number of people that she's a good person or a good cop. You heard from a lot of people in her police family. Members of the jury, good people can commit crimes. Police officers can commit crimes too. And it should come as no surprise that the defendant had a reputation for being law-abiding before April 11th. She was a police officer, and that is the expectation. And just because she didn't kill people for the first 25 years of her career does not mean that no crime occurred on April 11th. This case is also not about whether the defendant is sorry or whether she's remorseful. Of course she's sorry. Of course she feels bad for what she did. There's no dispute about that. But that has no place in your deliberations. Your duty, members of the jury, is to decide this case without sympathy. And you have an instruction on that. And without considering in any way any possible penalty or punishment. You've got an instruction on that too. Be fair, act honestly, deliberate without prejudice, bias, or sympathy, and without regard to your personal likes or dislikes. This case is not about remorse. It's about the defendant's actions in shooting and killing Daunte Wright. And you were all selected for this jury because you said you would follow the court's instructions and apply the law. That's your only job in this case. That's what you're here to do. In this case, the defendant made choices, a number of choices, and those choices killed Daunte Wright. She chose to engage, she chose to use force, she chose to escalate, she chose to draw the weapon on the right side of her duty belt, she chose to reach her right hand down to her holster, she chose to ignore the feel of that holster, she chose to ignore the weapon in her hand and how it came out of the holster, she chose to put her finger on the trigger, she chose to ignore the feel of the trigger. She chose to ignore the feel of the grip. She chose to ignore the weight. She chose to ignore the color. She chose to ignore that there was no display and no lasers and no flashlight of this gun that was in her right hand, right in front of her face, with her right index finger on the trigger, aimed directly at Daunte Wright. She chose to pull the trigger. She chose to fire. She chose to disregard her training and to disregard the cautions and the warnings and the risks. She knew she had both weapons on her duty belt. She knew how to get it right, but she failed to get it right. She failed Daunte Wright. The defendant alone is responsible for her choices and her actions. Daunte Wright did not cause his own death. We're here because this was entirely preventable. It didn't have to happen. It was a tragedy of her own making. And it's not just a tragedy. It's manslaughter. That she was an officer does not make it okay. That she was on duty does not make it okay. That she shot him with her service pistol does not make it okay. Her actions were rash and reckless, and what she did was wrong. We trust the police to safeguard lives. We trust them to do that until they don't. The defendant shattered that trust when she shattered Daunte Wright's heart. She chose right instead of left. She chose wrong instead of right. She chose her gun, and she shot and killed Daunte Wright. Thank you.
All right, members of the jury, we're going to take a 20-minute break. So we'll reconvene in 20 minutes. Please be seated. Okay, counsel, there's an error in the jury instructions that I think all of us missed. It's the instruction on evidence of character. It says that in this case you have heard evidence as to the general character and character for honesty of the defendant. We need to correct that because I'm wondering, I think that instruction should be reread to the jury and corrected on the jury instructions that go to the jury. What I was thinking of doing is that I'm going to be giving the jury additional instructions on the laptop and the evidence, returning for information and notes. I think I should reread that instruction, and I guess I'd like to hear your thoughts as to whether or not I tell them that there was no evidence of character for honesty in the case as well.
Peacefulness, right, Your Honor?
Pardon?
Peacefulness?
It was peacefulness and abiding by the law. There was no evidence, and I did not allow any evidence of character for honesty. Ms. Eldridge or Mr. Frank, do you have any thoughts on that?
Your Honor, we recognize that error in the instruction we never took out, and we would propose that the court just take out "and character for honesty." Just leave it, and just omit that phrase and advise the jury that it's been updated and read it to them again.
Okay.
That's, what you should do is just say, in terms of the character evidence, I want to read it to you again, so you don't emphasize the mistake. And say that the character for law-abidingness and peacefulness of the defendant, and then leave it at that. That's what you should do.
I think I should do a little bit more than that. I'll think about it over the break, but my thought is that I should tell the jury that the instruction that I read to them on character evidence was wrong. There was no evidence regarding Ms. Potter's character for honesty. And then reread the instruction.
With peacefulness in, Your Honor?
I'm not,
What's evidence of peacefulness?
You'd have to reread the instruction and say character for peacefulness and law-abidingness. That's the correct instruction. So we want that in there. You can't just take it off and then give them the impression that honesty doesn't matter.
okay, is there any objection to that from the state?
Actually, I think we should just leave it at general character, but I would oppose having the court say there was no evidence of character of honesty. I'm afraid that calls out, may cause them to wonder why. So I think it's better not to call out what we've taken out. And I think the defense probably agrees with us on that. Otherwise, Your Honor, the state doesn't oppose putting in what the defense suggests about what the actual character evidence was limited to by the court, peacefulness and law-abiding.
Okay. All right, so I take it that everybody agrees that I should tell the jury that the instruction on character evidence was erroneous and that I'm going to reread the instruction to them. In this case, you have heard evidence as to the general character for peacefulness and being law-abiding of the defendant. You should consider this evidence. Okay. And then there was also a typo on page 9. I read it right, but on page 9, paren 3, or should be an of. Okay, so very minor. All right, let's take a break, council.
We have a moment, Your Honor. Thank you. I'm done, Your Honor.
Yes,
And you did all that training.
yes,
And you did all that every year throughout that 26-year period, right?
yes,
Sometimes multiple times a year, right?
yes,
And all of those requirements were in place to make sure that you were at the beginning of your career and continued to be, competent and capable of performing the requirements of the job, right?
yes,
You mentioned on direct that you were also a hostage negotiator as part of your duties, right?
crisis negotiator.
Crisis negotiator. Did that involve some hostage type situations?
I've never had a hostage situation.
Okay, but crisis negotiation.
Yes,
And that involved some de-escalation tactics, I presume, correct?
yes,
And you had to develop that skill set and be pretty good at de-escalating situations as a crisis negotiator, fair?
yes,
So you had some experience in stressful situations doing that.
no,
So you were a crisis negotiator but never experienced a stressful situation?
we talk to people.
Talk to people in crisis.
Yes,
And part of your job as a police officer is dealing with people on their worst days, right?
yes.
People who don't want to cooperate with you sometimes, right?
Most of the people we talk to in crisis are either barricaded behind a door or talking to you from another room.
Okay. For 26 years, you were a patrol officer, right?
Yes,
So you saw people out on the street every day as part of your job duties. fair?
yes,
And you talked about doing a lot of traffic stops during that career, correct?
I did some traffic stops.
Okay. Well, in some of those cases, there are people who have weapons, right?
Yes,
Sometimes people want to flee, right?
yes,
Sometimes people are violent.
yes,
And all of that's part of being a police officer, dealing with people in those situations, right?
yes,
You'd agree that you're bound by policy and the requirements of the job that Brooklyn Center, the police department, sets for you, right?
yes,
And you heard Commander Fleslin testify, but you had to acknowledge those policies and essentially agreed to abide by them every year you were an officer, fair?
yes,
And you'd agree that your fundamental duty as a police officer is to safeguard life, right?
yes,
And you also have the duty to never employ unnecessary force. True?
yes,
Part of the policy also includes some of your responsibilities as an officer, right?
yes,
And that includes being alert and attentive and capable of performing your job, right?
yes,
And getting back to the training and sort of the post requirements, there's a lot of training that goes into being a police officer, fair?
yes,
And we talked about a couple of those things, but one of those subjects is use of force, right?
yes,
And use of force can include things like restraints, handcuffs, defensive tactics, chemical irritants using batons, tasers, less lethal weapons, and firearms as well, right? All those things are options available to you. True?
not all of them.
Okay, well, you carry a whole number of things on your duty belt every day, right?
Yes,
And that includes a firearm and a taser, right?
yes,
And you also had other items on that duty belt as well, correct?
yes,
And as part of the training that you went through every year, they cover topics, all kinds of uses of force, right?
Yes.
Including the things on your duty belt and maybe other options that the department could use additionally, true?
Only the things I was assigned on my duty belt.
Okay. But in any case, that use of force training was a pretty key component of being an officer, right?
Yes.
You were trained about when you could use force, how much force to use, and what would be appropriate force. Fair?
Fair.
And not only were you trained on that, but you had a lot of policy that that dictated what you could and could not do in a particular situation, right?
Yes.
And you were also trained on the readiness aspects of use of force, right? Being ready to engage whatever force might be required, right?
Yes.
Including making decisions under stress, right?
What do you mean?
Well, you had a lot of scenario-based training, right?
Yes.
And in those situations, those scenarios were set up to be as close as they could be to real life, right?
I suppose.
So you would be trained to have to make decisions in the moment about what to do and what force to use, right?
Well, it was a training situation, so it was usually slow and meticulous and controlled.
Well, you did this year after year, right, for the entirety of your career, correct?
I think scenario-based training started later, probably the last 10 or 15 years.
Sure, but use of force training has been around for a long time, right?
Yes.
Because since you started as a police officer, you have, in some cases, had to use force, true?
Yes.
And there are limitations on how and when to use that force, right?
Yes.
So you've had training on that throughout your entire career, right?
Yes.
And as part of that process, the way that it's required for you to maintain your license is that you sign in and you sign off on attendance forms, and you basically, you have to be there, right? You can't not be there, right?
Right.
And every year you have a certain number of training hours that are required, right?
Yes.
And you said on direct that you participated and you were paying attention during all those trainings, true?
Yes.
And some of those trainings had classroom instruction, PowerPoints, things like that, right?
Yes.
Some of them also included reviewing policies and other documents, right?
Yes.
And then there was also the hands-on training with the practical components, things like using drawing weapons, things like that, right?
Yes.
And over the course of your career, you completed many, many, many hours of training, right?
Yes.
And in terms of credit hours, we're talking somewhere in the ballpark of 1,700 credit hours. Does that sound right?
I don't know the number of hours, but if that's what you have, that would be probably right.
No reason to dispute that your training hours would have been in the thousands of hours over that 26-year career, right?
Yes.
You indicated that there weren't tasers available when you first started at Brooklyn Center, true?
No, they came in the early 2000s.
Okay. But in 1996, you had a firearm, right?
In 1995, yes.
Sorry, 95, and then you were sworn in 96, right?
No, I was sworn in February 27th, 1995.
Okay. So in 95, when you first started, you had a firearm available to you.
Yes.
And you were trained to use that firearm.
Yes.
Trained how to handle it, right?
Yes.
Trained how to load it and unload it.
Yes.
Trained how to draw it,
Yes.
right? And fire it. And how to safely handle it, yes?
Yes.
And that included when not to fire it, right?
I suppose.
And that training started at the beginning of your career, you said in 95, but continued every year up until the time you resigned, right?
Yes.
Now, you indicated that tasers came later, but you were first trained on using a taser in 2002, correct?
If that's what the documents say, I'm not sure when they came out.
And if the documents say you were trained in 2002, you then would have been trained every year thereafter, right?
Yes.
And you started carrying a taser on your duty belt regularly as of 2005, right?
Yes.
But at a minimum, in addition to all the other training you had, you would have had taser training year after year for at least the last 19 years, right?
Yes.
And the taser training that's required, you saw the documents that were in court, also requires not only it requires review of policy, right? The taser policy, right?
Yes.
And it also requires practicing those reaction side draws, correct?
Sometimes.
All right, if we could put up Exhibit 334, please, the last page. I'm going to put on the screen what's already been admitted as Exhibit 334. And we're going to scroll down to the very last page and highlight the subsection C, please. So, as part of the taser policy includes that all training should include performing reaction hand draws or cross draws to reduce the possibility of accidentally drawing and firing a firearm. That's part of the policy, right?
That's what it says.
And that's part of what you're trained to do, correct?
We didn't always we aren't always drawing our tasers from our holsters. A lot of times we were in plain clothes during training.
Okay. Well, your policy that you're required to abide by, that you signed off on, requires that you perform reaction hand draws, true?
During the training, yes.
It also includes the reason for that, right?
Yes.
And that's so that you reduce the possibility of accidentally drawing and firing a firearm, right?
Yes.
And we can take that down. Part of the reason for that is weapons confusion, right?
Yes.
And that was known in the field and has been known for a number of years. True?
I guess.
Well, you were trained on it, right?
We talked about it.
It was part of your PowerPoints, correct?
Yes.
You were made aware during PowerPoint after PowerPoint after PowerPoint that drawing and firing the wrong weapon can happen, right?
We were told it wasn't something that they expounded on.
You were told that.
Yes.
And you signed documentation every year you were certified acknowledging that you knew the risks, received and reviewed the materials required for you to carry that taser, correct?
Yes, I signed the document.
Okay. Now, in terms of the carrying of these weapons, reaction side means what for you?
That'd be my left hand.
Okay. You're right-handed?
Yes.
So carrying a taser, you have done for years on your left side, correct?
Yes.
And your firearm you carry where?
On my right side.
How many years have you carried your firearm and your taser that way?
My firearm for 26 years and my taser, according to your documents, for 19.
So as long as you've had that taser, you've carried it on your left side, correct?
In the beginning, I carried it on my right side in a drop holster.
And when did you switch?
When we were given new holsters?
And when would that have been?
I don't know.
Okay. But far before 2016, you saw the images that were up in court. Long before that, you were carrying your taser on your left side, correct?
Yes.
Years and years, right?
Yes.
We talked a little bit about reality or scenario-based training. When you go through those trainings, you have available to you all the options that would be on your duty belt, right? Although inert for the purposes of training, right?
Yes.
And the purpose of that training is to try to recreate real-life stressful situations as best as possible to practice making those types of decisions in the moment. Fair?
Fair.
Let's talk a little bit about your taser. you'd agree that the Taser 7 that you have and the Taser you had before that has a safety mechanism on the side of it, right?
Yes.
And you have to flip it up to arm the Taser.
Yes.
And when the Taser is on and armed, it beeps, right?
I don't know if it beeps.
There's a display screen that turns on.
Yes.
And then there are 2 lasers with the Taser 7 that appear on your target, right?
Yes.
A green one for the top probe, right?
I believe so. It was a new taser.
And a red one for the bottom.
I would guess so, yes.
Well, you were trained on it, right?
Yes, but it was a while back.
Well, you were
been a long-
trained in March of this year on that Taser, correct?
Yes.
And you have to successfully operate and handle that Taser in order to be certified to use it, correct?
Yes.
And you went through that hands-on process of turning on that Taser and safely handling that Taser in order to be certified, correct?
Yes, in March.
In March. And before that, you had an X26P, correct?
Yes.
And that Taser also had a laser and a safety and things like that, right?
Yes.
The screen that turned on.
Yes.
And the Taser, and that was the Taser that you had been carrying for years before, right?
Yes.
Very similar to the Taser 7 in that way.
Similar but different.
All right, so I'm going to put on the screen next to each other, please, Exhibits 210 and Exhibit 212. Now, this is a picture, side-by-side pictures of you on April 11th, correct?
Yes.
And your Taser is pictured on the left side of your duty belt, correct?
Yes.
And that's the way you'd been carrying it for years and years, correct?
Yes.
And your firearm you carried on the right side of your duty belt, right?
Yes.
And you'd agree that the standard procedure for a reaction side, left-hand draw for your Taser in this case, would be to draw that weapon with your left hand, correct?
Yes.
All right, you can take that down. You were asked some questions on direct about spark testing, the function test of the Taser. The policy says that you should do that before the beginning of every shift, right?
Yes.
And you didn't do it the last 2 shifts that you worked, correct?
That's what the documents say.
Right. You didn't do one for the last 4 of your last 10 shifts that you worked, in fact, correct? If that's what the documents say.
Which dates?
You didn't do it on March 27th, correct?
Uh,
I guess.
You didn't do it on March 28th.
Your Honor, I object to this cross-examination if she doesn't know. She should
All
have-
right.
she should have-
Okay, one-word objections, please. If she doesn't know, she can say she doesn't know.
The documents show that you didn't do a spark test 4 of your last 10 shifts. You have no reason to dispute that, right?
No.
And the day of this incident on April 11th, you didn't do a spark test that day, right?
No. According to the documents.
And even though, that day was a slow and uneventful day at the beginning of the day, right?
I don't know. I don't have a log.
Well, you told Dr. Miller that that day started as a slow and uneventful Sunday, right?
I don't know if I did or not.
Council sidebar.
Okay, you may continue. Please be seated. Okay, the defense may make its final argument.
Your Honor, counsel, Ms. Potter, ladies and gentlemen of the jury, I have not argued a case with a plastic shield in front of me before. This will be a first, hopefully the last. But before I get into my final argument, or summation, some people call it, we apparently were accused by the state in their argument that we might run you down a rabbit hole of misdirection. Rabbit hole of misdirection. That's what they said. Playing the video, not at the right speed, where it showed chaos, playing it as slow as possible, showing photos, that's the rabbit hole of misdirection. And make no mistake about it, Kimberly, Potter, Johnson, Lucky, and Wright were fighting, struggling, and it was in seconds that happened, not slow motion. So when you go into that jury room, play it like it's supposed to be played, not a rabbit hole of misdirection. Rabbit hole of misdirection, no threat by Dante Wright. He broke free from a law enforcement officer and took off in his car even after he was shot. No threat. Sympathy for Potter? Well, what are the photos of Dante Wright doing up there with his child? Does that prove anything on this case? Of course not. They're asking for sympathy, not us. Johnson not worried at the scene? In final arguments, you're to rely on your own memory of the evidence, and not mine, not hers, your memory. Well, that isn't what he testified to. Not worried, she says. No, could not see Johnson. Well, ladies and gentlemen of the jury, the body-worn camera is here. Her head's here. She didn't have the camera on her head. And when she's leaning in, of course the body-worn camera doesn't see Johnson. But her head does, and she testified she saw him, and his look on his face like she never saw before. That's the evidence. They have the temerity to talk about Stoughton, a man who had the power to charge up to $93,000, who doesn't remember being a police officer. When I ask him about crisis, he wants to go back to the training field. The temerity of saying that cops, because they're a family, lie. And then the spark test. She didn't do the spark test, so that's evidence of recklessness. What a catch-22, ladies and gentlemen. They also used the fact that she went to each and every training session, each and every one of them, and there was evidence from one person that she paid attention. Can you imagine if she did, and they're using that to say she's reckless. Can you imagine If she didn't go, oh my gosh, they would call her criminal, reckless. She missed a session, but she didn't. And now they're holding that against her. What a catch-22 that is. So there, I'm not going to run you down a rabbit hole. I'm going to try to make a reasonable and sensible final argument based on the evidence. However, if my recollection is different than yours, rely on your recollection. You are the jury, and you have the power to disregard what any lawyer says if your memory is different. I'm not going to try and misstate the evidence. I'm going to try and state the evidence. Once in a while, lawyers make mistakes, just like anybody else. First thing I'm going to do, have a drink. First thing I'm going to do is talk to you a little bit about proof beyond a reasonable doubt and the presumption of innocence, because that was left out of the state's argument. And the presumption of innocence, it means what it says. Your duty, your constitutional duty, is as jurors to presume Kim Potter innocent. Not guilty, innocent. That she's innocent. And before you can find her guilty, you must find that each and every element of the charges is proven beyond a reasonable doubt. Beyond a reasonable doubt means what it says. It's a type of proof you'd act upon in your most important affairs of your life. And make no mistake about it, ladies and gentlemen. This is a most important affair of my client's life and ours. It's a type of proof, I believe, that 10 years from now, when you look at yourself in the mirror and you say, by golly, I did the right thing when I found Kim Potter not guilty of both counts. That's beyond a reasonable doubt. There's also one other constitutional right that's important, and that is a person's right to a jury trial. A jury trial like this. We have the state prosecuting, we have all government workers, and our forefathers believed that in order to find somebody guilty or not guilty, a jury, a fair jury, should be called, and they are the ones that apply the presumption of innocence and proof beyond a reasonable doubt. And that's your job. You have to enforce those constitutional rights. That's the constitutional right of a jury trial. Jury of your peers. A fair and honest, unbiased jury. When you're asked in your questionnaire, could you presume somebody innocent? Well, you all answered yes, or you probably wouldn't be on this jury. But when you think about it, which you probably didn't as much then, presumption of innocence is that she didn't do it. And every day of your life before this trial, I can't recall if any one of you has been on a jury before, but every day of your life, you read the paper, you hear on the news, the media, whatever, that they arrested somebody. And in your brain it says, oh, they got the guy. You can't do that here. That's not the law in a courtroom. It's outside the courtroom. In the courtroom, you must presume innocence, that my client is innocent, our client. And that's a very important presumption, and we'll get into that. So, and these constitutional rights were enacted a long time ago by our forefathers. And what they did to enact them at that time was to protect our freedom. Protect our freedom from overreaching government and from biased people and from mob rule. That, hey, you can't lynch that person. We're giving that person a trial. There's no mob rule, and we're going to be fair about it. So that's what we're doing here, ladies and gentlemen of the jury. We're giving Ms. Potter a jury trial, and in that jury trial, we're going to presume her innocence, and we're going to require the state to prove each and every element of the crimes. And in doing this, I'm going to sort of categorize here. I'm going to get into the evidence right now. I'm not going to give a real lengthy argument, but the first category I'm going to talk about is causation. That's the first category. Let's look at the causation in this case. And to do that, we have to look at the instructions of the jury. In the instructions, and there'll be, I got scribbling on there, but you'll get a copy of this back in the jury room, and it's extremely important. The importance is this. I'm going to read it. To cause the death, causing the death or cause the death means that the defendant's act or acts were a substantial causal factor in causing the death of Daunte Wright. The defendant is criminally liable for all the consequences of her actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were a natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. Here's the however, and it's extremely important, particularly when the state argues that Daunte Wright had nothing to do with his death, which is absurd. This is, however, the defendant is not, Kim Potter is not criminally liable if a superseding cause caused the death. What's a superseding cause? Is a cause that comes after the defendant's acts, alters the natural sequences of events, and this is the sole cause of a result that would not have otherwise occurred. Let's look at that superseding cause. Let's look at the evidence. Substantial factor. What happened here? We got a Sunday afternoon in the spring, April 11th, and an FTO officer, my client, our client, and Mr. Lucky, Officer Lucky, were driving in their town, Brooklyn Center. They see a car that was going into a right turn but then decided to go left. They see the thing on the end windshield or whatever, and they also see that the license plate is not registered. Our client did say that she might not have even stopped them. But Lucky, Officer Lucky, who was a trainee, she was the FTO, wanted to stop him for the thing hanging on the window and the registration. He first saw the thing on the window, and then when they got closer, they saw the registration, or they checked on it. In any event, they stopped them. Everybody agreed that was a legal stop. They were doing their job on Sunday afternoon in Brooklyn Center. After they stopped, Lucky and my client got out of the car. Lucky went up to the door. You heard, and you can listen to it again, hopefully at the right motion and not slow it down until forever. Do it at regular motion. He goes up there. He says, "Hi, bro," something like that, very nice. Asks him for his insurance and driver's license. I think he tells him something about the thing hanging on the window, on the mirror. And he doesn't have a license. He doesn't have insurance. And he gives him an insurance card with somebody else's name on it. And Lucky smells marijuana and sees some in the car. Well, that's consistent, because as you learned, he smoked a joint with his passenger that morning when they got up early. And I asked what time. 10 o'clock in the morning was early for this couple. After that, they smoked a joint. And what's even more corroborative of that is the forensic pathologist says 4.3L, I believe it's something like that, is a high reading. So we know now that circumstantial evidence, which you'll see in the instructions, reasonable inference, he has that kind of reading, he's stoned. He's got marijuana smell in his car. He's got seeds on the floor, shake, Lucky called it. So Lucky goes back to his car, and Kim Potter goes back. They go in the car and they do a warrant check, that's legal, that's proper, that's their job, that's what they're supposed to do. And lo and behold, Daunte Wright has a warrant, a bench warrant. In other words, he didn't show up in court for a weapons violation. as Lucky said, that raises the antennas. Oh, there might be a gun in this car. And Lucky said, and he grew up in this neighborhood, he said that 2 in 5 cars have guns in it. So that raises the antenna for these two cops. In the meantime, they called for assistance, which is regular police work. They do that even on a traffic stop. And Sergeant Johnson shows up. So we now have the 3. And they see that there's marijuana, no license, no insurance, a warrant, a bench warrant for a weapon, and a TRO, or restraining order, where some lady, accused him of harassing him. That's what we had. That's what these police had when they walked out of that car. When the 2 walked out, Sergeant Johnson was already right there. And they go up to the car, and everything up to this point, Kim Potter's acts, Lucky's acts, Johnson's acts, are all protocol. They did everything right. And once Lucky gets up to the car, he tells Dante Wright to get out of the car. Dante hesitates, says why. I believe the evidence shows, if you listen, if it does show it, that even his passenger said, go get out of the car. But anyway, he hesitated, and he said why, and then he got out of the car. And Officer Lucky, being a nice guy, I mean, he could have taken him and thrown him against the car and put his knee on his neck. No, he said, put your hands behind your back. I'm going to handcuff you. And at the same time, Sergeant Johnson says, you have, and he wants to know why, you have a warrant. Now, Dante Wright realizes there's a warrant for his arrest. And he knows what it is. So, within seconds, he all of a sudden breaks away. That's the cause, ladies and gentlemen of the jury. That's what caused this whole incident. If he would have gone and with the officers, been handcuffed, go to the squad car, go take your ride downtown, and it's over. That is called, as the law states, a superseding cause caused the death. Because everything after that, the officers did, they did to try and restrain him, try and stop him from leaving. And don't listen to Stout. This Stoughton guy saying you should just wave at him and say goodbye and let him go? With a weapons bench warrant, with a temporary restraining order, he's stoned. You don't let that, that's not protecting the public, and that's not serving the public. They had to stop him. And he watched the video, and he's fighting. My client, our client, goes around Lucky and grabs her gun instead of her taser. She thought, and I don't think there's anybody here, even the state, would contest the fact she thought she had a taser. It was within seconds. You watch it. It was chaos. She's going around here, and Johnson, he's in the car now, holding on to the shifter and onto the key, and then he grabs Dante Wright's arm. And you know, I once mentioned in this case, and I got a little giggle, I guess, from the state. I said, what would have happened if that car would have went in reverse? Oh, it wouldn't go in reverse. He couldn't go in reverse because there's squad cars back there. Well, what about if it accidentally, from the park position, accidentally went down to reverse when he was struggling to get it in drive? What would have happened then? A very dangerous situation for everyone, the officers and Wright. So they're fighting, they're struggling, whatever you want to call it, and Wright's putting up a good struggle. He doesn't want to go to jail. So Kim Potter, I got the seconds, where Kim Potter comes around and she says, I'll tase you. Now, all the time before that was police work, good police work, trying to stop him from leaving. And then she comes around and tries to de-escalate, it's called, the situation by saying she'll tase him, thinking that she had her taser. Why didn't he stop? 2 cops are fighting with him. There's another police officer that's saying he's going to tase him. He didn't want to go to jail. He wasn't going to listen to these police officers. 4 seconds later, and you'll see this, and make it chaos, because don't slow motion it, make it at the right speed. She says again, to de-escalate it, to say, hey buddy, stop, I'm going to tase you. Nothing happens with him. He fights, he struggles more. Watch the video. And then, a couple seconds later, I think 4 seconds, I believe, she says, taser, taser, taser. And he said, okay, stop, I give up. No. Would she have tased him if he ever said that during those seconds? That he was struggling, that he wanted to leave? Would he have said, I'm not going to go, I'm not going, handcuff me, I'll go to jail? No. And that's the cause. That's everything before that the police officers did as they were supposed to. In fact, it was a very procedurally right reasons for them. So, the causation, get my notes here, the causation was Dante Wright. And, sometimes things happen that are unexpected, but they save a life or they save serious injury. Because when Kim Potter said, taser, 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 that's a signal for the law enforcement officers to take their hands off him, which they did. And then a second later, she shot him, tragically. But she didn't know she had a gun either. And then he said, you shot me. And being alone, what does he do? Does he stay there and say, hey, help me out? He takes off then. And you see the video, he goes like a jet. He drives in danger, he's shot, he drives in danger. He really wanted to get away. And what you can reasonably infer from that, you can reasonably infer that he knew he was guilty of that weapons violation. And he didn't want to go to jail and run the risk of a criminal case. He left to get out of there. Unfortunately, and he was able to leave. He said, you shot me. He drove down. The forensic pathologist said he could have been alive for up to a minute. So you heard the crash. I believe it was about 10 seconds that the crash happened when he took off down the road. And that, what's really interesting here, and I don't know, jurors, you're probably wondering a little bit too, but why are we watching all this stuff about the car accident? Why is that part of this case? Kim Potter didn't drive that car down there. Kim Potter didn't tell him to drive that car down there. He, on his own volition, while he was alive, drove down there. He should have stayed. Maybe he would have had some medical help from the officers Potter, Lucky, and Johnson. Think about it. Yet they show all of this. They show the poor ladies, the lady, Miss Lundgren, and her husband's and physical health, bad physical health. They show that. They show her daughter, and it's all got nothing to do with this case. But you know why? You know why they're doing that? They're trying to run you down the rabbit hole, as she says. They want sympathy. They want sympathy. They want to blame that on our client. Think about it. How could she be at fault for that? He purposely decided to drive away. He just didn't want to go to jail. So that's the superseding cause. The judge will instruct you. As it is here, it's the last sentence. I'm not saying something that's not there. A superseding cause that comes after the defendant's acts. Her acts were all legal. Everything she did was legal. And then he tries to break away. And consciously, she thought she was doing the right thing. So the state There's only, that's an element too, by the way. I don't know if I mentioned that, but the element for for both crimes is, second, the defendant caused the death of Dante Wright. Kim Potter caused the death of Dante Wright. The death of Dante Wright was caused by the defendants committing a reckless handling of a use of firearm. Cause. And that's in the second elements of manslaughter too. The defendant caused the death of Dante Wright. So I could stop right here, because if you presume what you have to do, if you presume that she did not cause the death, what you have to do by the presumption of innocence, did they prove beyond a reasonable doubt that she caused this death? No. Dante Wright caused his own death, unfortunately. But those are the cold, hard facts, the evidence. So I could sit down now because they didn't prove that element, but we're going a little bit further. I apologize, it'll be a little longer. And the second issue that I'd like to talk about is the authorized use of force. And the authorized use of deadly force is the first defense. And the state has to prove that they have the burden, and I'm going to read it to you. The defendant is not guilty of a crime if he used deadly force as authorized by law. This is important. To prove guilt, the state must prove beyond a reasonable doubt that the defendant's use of deadly force was not authorized by law. And when you look at that, you also look at the presumption of innocence. And you must presume that she had a right, authorized use of deadly force, that she had a right to do it. That's the presumption of innocence, and the state has a burden to prove beyond a reasonable doubt that she did not. And the other interesting factor that wasn't mentioned is that you can't hindsight these things. You can't say to the officer, well, now, wait a minute. You didn't spark your gun or your taser. You went to all those training sessions, so you should have known it was a taser, or gun, not a taser. It's not should have known, and we'll get to that. But let's first look at defendant's authorized use of deadly force. First off, there was a vague argument that the officers are a family, so they're lying. They're not telling the truth. They're helping Kim Potter out. They're a family. Come on. You saw all of these officers. Were they professional? Yes, they're college graduates. They came before you and told the truth. They weren't impeached by anything. A family? Major Johnson is no longer in Brooklyn Center. He's down in, I believe, Goodhue County, down in Red Wing. He's a major down there ahead of patrol. Is he the kind of guy that would lie about something? No. And the other officers? The commander. Is he part of the family? No, he knows her. He thinks he's a good cop. So to argue that these police officers gave their opinion because they wanted to protect Kim Potter, they know what the oath is. They know what a crime is. They know what perjury is. They're not going to do that. That's going down the rabbit hole, I believe. In any event, remember the auto accident? And there's this one picture, I believe, and Dante Wright was lying on the ground. I think there were 6 or 7 police officers around him trying to revive him. Police officers aren't thugs. You've seen these officers. To say that they would color their testimony to help their friend out is outrageous. It's simply not fair. And as far as the authorized use of force, they paraded their own witnesses, the state's witnesses, Major Johnson. I asked him, well, were you in danger? I can't remember exactly what I asked him, but basically to show that he was in grave danger or might get killed by him wrestling with Wright while leaning over the car. Maybe he wasn't sitting in the car, but he's 6'2", leaning over and grabbing that shifter and grabbing his arm. If he would have been able to get that shifter going and get it going, what would have happened to Johnson? The worst would be death. If he took off like he did as a jet, the least would be serious injury. And when I asked him that, what did he say? And this wasn't contrived. It wasn't, no evidence that it was made up. He said, he quoted 60966, which is in the instructions, that on deadly force. He cited the statute. That's what he believed. That was his take, and he was there. He wasn't in a classroom or in Florida watching a video. He was there. He was the man leaning over and struggling with this guy. And when you're taken by surprise, thinking all common sense, reasonable infer, when you're taken by surprise like Wright did, and you're relaxed before that, and you're doing these things, and all of a sudden he won't give up, that's Alton can say what he wants. But what did James say? After hearing the testimony of Johnson, no question that Officer Potter had a right to use deadly force. Even though she didn't know she was using it, she had a right to. And that's what the law is. And they have to prove beyond a reasonable doubt that she did not have a right. And what do? The only person they call is Stoughton, the $95,000 contract a year guy. Stoughton, who has not been a cop for 15 years. He was a police officer 5 years and doesn't remember if he ever had a crisis. He wanted to talk about field training. It's hard to believe our state of Minnesota would do that. Would hire some guy like that, and you compare him against James, 40-some years as a cop, all the things he's accomplished in his life. And Stoughton, and you have a right, there's an instruction, you have a right to compare like the believability. You can look at that instruction here about experts. You have a right to look at that. Their bias. Is there bias? I don't know. He gets paid, he can be paid up to $95,000. Our expert, he doesn't charge. He chooses not to charge. He drove up here having a heart surgery 2 weeks ago. That's how strong he believes in the fact that she could use deadly force. Lucky, he also, he was here, he was in it, he was involved in this struggle. He said that Kim Potter isn't going to jail. She's not going to jail. That's what he said. In his opinion, Kim had a right to use deadly force. But we don't stop there. Then we have Fleslin. Garrett Fleslin, a commander, been in the Navy 10 years, 21 years as a police officer. He's the commander at Brooklyn Center. And he said, on the hypothetical I gave him, and it was a hypothetical exactly, and you can check your notes, you can remember his testimony, the same hypothetical that happened at this scene. And he said, yes, she could use deadly force in that situation. That's two of their witnesses. Then we've got Gannon. We call Gannon the chief of police, ladies and gentlemen, a man who was in the Marine Corps, a man who fought in battle for our country, a man who wanted to give Kim Potter due process, and he got terminated for it. Think about it. He takes a stand. He gets the same hypothetical. Yes, deadly force. They have to prove beyond a reasonable doubt that she did not have a right to deadly force. We've just proven through 3 witnesses that she did under this circumstance. Do any of those officers, Chief Gannon, he doesn't work there anymore. The major doesn't work there. The commander, he isn't too worried about his job, are they the kind of individuals that would lie, that would give a false opinion? No. Think about it. Look at the instruction on that. But we're not done there. I have another, there's two absolute reasons why she's not guilty. Absolute. She didn't cause this, and she had a right to use deadly force. We proved it. And all we have to do is establish reasonable doubt. They have to prove it under reasonable force. But we have another one. The third reason that there's an acquittal here and not guilty is because of the statutes. And the state brushed over this a little bit on the elements. Let's look at those elements a minute, and let's rely on what the language, what words mean. So we go to, I'll get it. We go to first the reckless use of a firearm. We've already talked about the cause of death. That's one element they didn't prove. But there's also two definition of reckless. You'll see when you read these. And a person acts recklessly if under the totality of the circumstances she commits a conscious or intentional act in connection with the handling or use of a firearm. Conscious. Conscious, we all know, means being aware you have the firearm. You have to be aware of it. How could you recklessly handle it if you don't know you have it? And there's no evidence that she knew. Every piece of circumstantial evidence, I'll tase you, taser, taser. She didn't know she had a weapon. She didn't know she had a gun. And that's what the element says, conscious. She wants to talk, the state wants to talk, well, she had all this training. She should have known. No, it's at this point that she knew she had a gun. How can you recklessly, consciously handle a gun if you don't know you have it? If because of the exigent circumstances, the emergency, whatever it was, the mistake, it's totally believable and totally true that she didn't know she had her gun. She never shot her gun in 26 years. Never even shot the taser. And you might think, oh, geez, probably a lazy cop. Really? How many volunteer programs was she involved in when she was working at Brooklyn Center? No, it's a good cop, and all the officers said so. But the person acts recklessly if under the totality of circumstances she commits a conscious or intentional act. And then you go on the totality of circumstances, you go to authorized use of deadly force. And when you look at whether or not they're authorized to use deadly force, and it's in here, it's limited by what a reasonable police officer in the same situation would believe to be necessary. To determine whether or not the actions of the police officer were necessary, you must look at those facts known to the police officer at the precise moment she acted with force. Split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. How could she recklessly handle a firearm when, in that situation, she didn't even know she had one? And the element, you'll read it when you get in there, the two elements of reckless handling, she commits a conscious or intentional act. Well, let's go on to the next crime. You might ask yourself, why is she charged with these crimes? But that's for another day. We don't talk about that. But the next crime, manslaughter in the second degree, the defendant caused the death of Daunte Wright. She didn't. By culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. She could not consciously take a chance of causing death or great bodily harm if she didn't know she had a gun. You'll get this in there. It's the second element. Read it. They have to prove that element beyond reasonable doubt. and they don't have it. They have no conscious evidence in this case. Everything she said, she believed that she had a firearm. Or, excuse me, that she had a taser. The next area, another basis for acquittal for not guilty, is the simple answer, mistake. She made a mistake. The company that makes tasers recognizes that they, even though they do all these things to guard against it, they have the police officers sign a piece of paper saying that they understand this and that. They do that so they don't get sued, but you could be trained forever, and under exigent circumstances, you can end up making a mistake. We called Dr. Miller. Dr. Miller, we didn't hear anybody saying he wasn't a professional psychologist who deals in mistakes like he did. He talked about the brain power. I'm not going into all that. Frankly, I didn't understand all of it, but I do understand this, that in the walk of life, nobody's perfect. Everybody makes mistakes. And some of those mistakes are small mistakes, but some of them are very serious. And she obviously made a mistake. It's called an action error. He explained that, how the brain, the dominant brain, takes over the other brain, and you draw your gun instead of your taser. You know, and they mentioned doctors. Doctors, I've never heard of a doctor being charged with making a mistake. And we know, common sense, history tells you that they've made many, and many have caused death. Many have caused serious injuries. They're doctors. Pilots make a mistake, the plane crashes, everybody's dead. If the pilot survives, he doesn't get charged with a crime. Mistake. I suppose the lawyers make mistakes. If you make a mistake and you're under the pressure of a trial and you're defending somebody and you make a mistake, what happens? Your client ends up in prison. That's the kind of pressure you have. And you think about it, ever since, man, everybody makes mistakes. Nobody's perfect, ladies and gentlemen. And this lady here made a mistake, and my gosh, a mistake is not a crime. It just isn't. It just isn't in our freedom-loving country that we're going to put you in jail for a mistake you made, even though you took all the training, even though you did everything, you made a mistake. And what does the taser people say? Well, we recognize there are confusions. There are mistakes. We recognize that. Well, if they do recognize it, let me ask you a question. Why do they have the taser shaped like a gun? They have yellow on it and all that stuff, but why is it shaped like a gun? Why isn't it a flashlight? Why is it in a holster on their belt? Why isn't it up here by their chest? Think about it. Why? Because they can sell more of them if it's shaped like a gun in a holster. Of course, they're in marketing. They're marketing it. So, and when you look at that mistake that she made, you look at the character witnesses we called. And character witnesses weren't there. They've just known Kimberly Potter for many years, and they think the world of her. And they say that she's a peaceful person, not a bully. She's never been accused of a abuse of force, of being a bully cop in 26 years. That's a record. Believe that. She's peaceful. And she's a law-abiding person. You heard the witnesses. One witness said she was like my mother when he was a neighbor of hers. And one of the reasons that you are a good person throughout your life is when something like this happens. When you're falsely accused of a crime and you're innocent, you go back and you say, oh my gosh, I've been a good person all my life. I want to get some people that know me and have them tell the jury that I'm a good person. That's one of the reasons you are a good person. You want to rely on your reputation. And on, by the way, in the instructions you get, there's a instruction. Character evidence. In case you've heard, excuse me, in case you have heard evidence as to the character of the defendant, you should consider such evidence with all the other evidence in the case in determining whether or not the prosecution has proven the defendant's guilt beyond a reasonable doubt. So our law, our jury instructions recognize that the reputation, character evidence is important in a criminal case. Finally, and I'm almost done, don't clap. We have Kim Potter. She testified. You saw her. I don't believe, and rely on your notes, I wrote it down somewhere here that they claim she admitted something. I contest that. Look at your notes. Kim Potter took the stand, and she said she saw Johnson, that she saw him and he had a look on his face she'd never seen before. And that was right before she said, taser, taser. Now, they want to argue that the body-worn camera, if we run it real slow, you can't see that. Well, of course you can. The body-worn camera is here. It's on the body. Her head's up here, even though she's 5'3". She can still see in the car. That's an outrageous argument. It makes no sense at all. They're relying on the slow motion of the body-worn camera, not the fast speed. If you saw it in fast speed, it's chaos. And then she tells you about why she became a police officer. She became a police officer because when she was grade school, a police officer, she knows his name, Mike McGee, came to school and talked about bicycles. She decided that day to be a police officer. She was a school officer letting elementary kids walk across the street when she was in junior high. She was an explorer in high school, continued to be an explorer, went to college at St. Mary's, took law enforcement and sociology, and took the training. First worked at the Anoka State Hospital, then she got a job in Brooklyn Center. And she worked there for 26 years, ladies and gentlemen. 26 years in which she volunteered for domestic, helped the victims in domestics, going to the death of officers and handling that. Crisis intervention, all of these things she did, and there's other ones I'm not going to, that she was very interested in helping people. And that's a sign of good character. Does that tell you that she did not know she had a gun? Of course it does. Does that tell you that she used reasonable force, deadly force, because she saw Johnson? She didn't know she had a gun, but she did shoot her taser. And by the way, there is an instruction in here about using the taser. And the reason that's there is because I believe Stoughton said that, she couldn't even use non-deadly force. It doesn't find her not guilty, the non-deadly force. The judge will tell you that in the instructions. But it will also tell you about non-deadly force. And Stoughton, he would say, no, you can't use non-deadly force, you can't use a taser. You have to just let them go. Does that make sense, ladies and gentlemen? So that's why that's there, because Stoughton said that. You decide the credibility of Stoughton. That's it. I'm done, ladies and gentlemen. I probably will sit down and remember 10 other things I should have said, but I'm finished. The Potter family thanks you for listening to this case. It's a very emotional case, but you have to look at the law and the evidence about, did she have a right to use deadly force? Of course she did, whether she knew it or not. All those officers said that. She didn't know she had a gun, so how could she consciously, recklessly handle one? And above all, in the first one, causation. Everything they were doing as good police officers until Daunte Wright took it upon himself to flee. He even left after he was shot, purposely. So, on behalf of my client and her family, Mr. Ng and myself, and Amanda Montgomery, the brains behind the operation, we thank you for your careful attention in this case. And if you look at the evidence, the believable evidence, follow the judge's instructions, it's not a difficult case. They failed in every element, miserably failed. And I hope that you come to the fair conclusion of not guilty based on the evidence. Kim Potter isn't guilty of these crimes. Thank you.
Members of the jury, we're going to take a 10-minute break before the state's rebuttal, okay?
Uh, 42,
And what city do you live in?
Minneapolis,
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright?
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Dante Wright, Destiny Wright, and Diamond Wright.
And is Dante, your son Dante, is he no longer with us?
No.
Was Dante the oldest of the 3 children?
Yes, he was our firstborn.
What was Dante's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife, Katie, and your children, Dante and Diamond and Destiny, all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
She had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Dante growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, I mean, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have, so.
Cookouts, you said?
Cookouts constantly every Sunday, every weekend, pretty much.
Did Dante have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So,
Was that a family favorite at the cookouts?
pizza. Excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He was a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Dante worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you guys
Yeah.
stopped working together? How was it for you working with your son, Dante?
It was great. It was challenging, to work with my son. I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like it was this one time where I had sent him home. Because he was on his phone at work and he wasn't supposed to be on the phone at work. I was like, yo, we gotta go home. And so he went and asked my boss, is it okay if my dad sends me home? And I'm like, my boss like, yeah, he's your boss. And I'm like, well, you need to go home and come out in the hallway. And he's still there. And I'm like, well, why are you still here? And he's like, well, Dad, I rode with you. I couldn't go home because you're my ride. I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from
Yeah,
work together?
every day, yeah.
You got to spend some quality time together.
Yeah, spend a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Any objection to 240? Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Dante. You see how, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed
This
away?
was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Dante also have a son of his own?
Yes.
And
First and only child. That's my grandson, Dante Jr.
And your grandson's name you said is Dante Jr.?
Yes.
How was it seeing your son Dante as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Dante Jr. spend a lot of time with your family as well?
Yeah. Dante Jr., you know, Dante lived with us. Junior was pretty much there every day. And he loved his son.
And did you love your son Dante a lot as well?
A lot. I loved Dante. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
So, you ready? Let's see, where's Mr. Ng? Okay, thank you, Deputy. Please be seated. The state may proceed with rebuttal.
Thank you, Your Honor. Members of the jury, Dante Wright was shot to death by a gun in the hand of a highly trained police officer veteran. That is what this case is about. No matter how hard the defense tries to recharacterize the case, distract you from the law and the actual evidence of the defendant's conduct, that's what this case is about. This case is about a 26-year veteran police officer who trained every year on the use of her gun. She had to qualify every year on the use of her gun to keep her license, who trained every year since 2002 on the use and handling of a taser, training that included the concept of weapons confusion and wearing it on the other side from your handgun, training that included proficiency. You heard Sergeant Peterson explain that means being able to draw the taser and handle it. Who had years and years of wearing and drawing that taser from her left side. Who during this incident had two officers with her who were subduing Mr. Wright, who, whether it was a good idea or not, decided to use her taser, but who instead disregarded those years of training and practice, pulled her gun with her right hand instead of her taser with her left hand, thought enough to give the verbal warnings, but not enough to realize, to be aware, she was pulling her gun. My review of the video, you rely on your own review of the video, But she has her gun in her hand, pulled out of the taser for some 7 seconds. Somewhere between 5 and 6 of those seconds, she has it held out in front of her. And then she shot Mr. Wright in the chest from a foot or two away. There's no mistake defense. You will not see an instruction on the defense of mistake. The judge will not give you an instruction that says a person is not guilty if they commit a mistake. That's not the law, no matter how often the defense says mistake. How can you recklessly handle a firearm? That's exactly the point. Right? She pulled her handgun instead of her taser. And that was her apparent intention, was to pull the taser. That's recklessly handling a firearm. That's how. These alleged crimes are based on recklessness, the reckless handling of a firearm by a highly trained professional who is trained to know about the risk of confusing a taser for a gun, or the other way around, and who pulled her gun and shot Daunte Wright. These alleged crimes are based on a trained police officer's conduct in deciding to use a weapon, being aware of the risks of drawing the wrong weapon, and then disregarding the risks and shooting Daunte Wright to death. Being aware of the risk. That's what the law is in this case. Now, you have heard testimony about whether Potter's decision to use her taser was reasonable or appropriate. The judge has given you a definition of reasonable force, reasonable use of non-deadly force, in case you want to consider that testimony and the legal requirements about her decision to use a taser. Mr. Gray, criticized us for putting in evidence about the crash and the Lundgrens. Here in this trial, that testimony was offered to you to show exactly what officers are trained to think about collateral danger. Right? Shooting somebody who's in a position to operate a vehicle, officers have to think about that. And that's exactly what happened here. Except Officer Potter did it with her gun by shooting Daunte Wright in the chest. That's why that evidence was offered. When you consider the defense argument, incidentally here for a moment, think about criticizing us for putting in evidence that has relevance to the issues. But the defense put in character evidence about Miss Potter and concluded with that, arguing to you that she's a good person. What's the relevance of that testimony? She may be. What's the relevance to the issues in this case? Mentioning that Mr. Gannon was a Marine, and I think...
Object to that. Obviously, character evidence is relevant.
The objection is overruled.
Mr. Gannon, who served as a Marine, and I thank him for his service, I'm sure we all do, and it's impressive. He pointed it out to you today. What's the relevance of that testimony? Anyway, ultimately, you really may not have to decide whether her decision to try to use a taser was reasonable, because that is not a defense to the charges. It's right in the judge's instructions. It's not a defense because the conduct at issue in this case is firing the gun that killed Daunte Wright. Whether her decision to use a taser was reasonable, appropriate, wise, may be considered by you to determine, based on the totality of circumstances, her entire course of conduct. But it is not a defense to her use of deadly force, what she actually used. I'm going to address the issues raised in the defense argument in slightly different order. We'll first talk about the argument about using deadly force. Counsel said you can acquit her because she could use deadly force. This is primarily based on a contention that Sergeant Johnson was in a position to fear. Well, what's required is that there be evidence of an apparent belief of death or great bodily harm. This claim is simply wrong based on all the evidence in the case. Her conduct, the facts that would have been known to her, and her testimony. This defense argument about the use of deadly force, when she has said at the scene she did not mean to use deadly force, is a justification, an after-the-fact justification to avoid consequences she acknowledged immediately out there on the street. The judge has told you to use your common sense in deciding the issues and the believability of witnesses. Common sense tells us all that often when people try to make up justifications later for things they have done, the justifications fall apart because they just can't line up with the facts. The facts exist. You have seen them. And if they can't be hidden or obscured, they render the justification incredible. Here's a simple illustration, I think, of what I mean by that. Ms. Potter wants you to believe that Mr. Wright was not in a position to operate the vehicle so as to justify her use of the taser. Because if he's not in a position to operate the vehicle, it's okay to taser him. I brought in Mr. Imes to tell you that. And they had people say, well, he wasn't in a position to operate the vehicle. But yet, they also, Ms. Potter wants you to believe that he was in a position to operate the vehicle to justify deadly force to protect Sergeant Johnson and Officer Lucky. Those things are inconsistent. And that's the problem with trying to create justifications later. Now, which is it? The evidence will tell you which it is. Ms. Potter did not believe that the use of deadly force was necessary to protect anybody. She just wanted to keep Dante Wright from fleeing a traffic stop her probationer had initiated. Mr. Gray is right. The state has to prove that Ms. Potter's use of deadly force was not authorized. He's right. That's our burden. You'll see that in the instruction, plain as day. That instruction also says that deadly force is authorized only if a reasonable officer, knowing what the officer knew at the time of using force, would have believed deadly force was necessary to prevent great bodily harm or death. Potter's assertion now that she could have used deadly force to protect the officers is simply not supported by the evidence. First, consider the testimony from Lucky, Johnson, and even if you will, Flesland, Gannon. Those statements, that testimony, simply lacks credibility. Look at the videos. You believe your eyes. Look at the videos. Watch them in real time. That's fine. I encourage you to do that. We slowed them down so you could understand what's happening there. But sure, watch them in your own time. I agree with that. But you can believe what you see in those videos. What you see in those videos is Dante Wright never assaulted these officers. The characterization of fighting and struggling is not supported by the evidence. Those are just terms used, not supported by the evidence. He was trying to flee, no doubt about it. But he was not struggling or fighting with these officers. He simply pulled away, tried to operate the car. He never even threatened the officers. Nobody has disputed those facts. You saw in the video during the testimony of Sergeant Johnson that he had control of the car and Dante Wright. He reached in, tall man, standing firmly on the ground next to the car, leaned against Elena Albrecht Payton, who obviously didn't put up any resistance to an officer of his size, didn't put up any resistance, just leaned against her, put his right hand on the shift knob, and you can watch that video and see Dante Wright's hands reaching for the shift knob, but he can't move it because Sergeant Johnson has control of that shift knob, and he's reaching up to shut the car off. During that time, Sergeant Johnson says something to Elena Albrecht Payton, something like, just stay back. Listen to the calmness in his voice. You know, is that the voice of an officer with a look of terror on his face that a 26-year police veteran had never seen before? Then, Sergeant Johnson stays in the vehicle, not in the vehicle, leaning in, and he takes his hand off the shift knob and is able to grab Dante Wright's right arm with both of his hands and pulls Mr. Wright's right arm over in front of Elena Albrecht Payton in the passenger seat. He's not concerned about being dragged. He's subduing Dante Wright. And he's doing that because he assumes Lucky on the other side is going to grab the other arm and they're going to be able to handcuff him. That's what his testimony was. Spotter's trying to make much of Johnson's testimony. Remember that these were leading questions put to fellow officers. I'm not saying officers lie. The judge will instruct you when considering the believability and weight to give testimony. Think of the relationship between the parties. These were leading questions put to Officer Johnson. His question was, what would have happened with you halfway in the car? That's my recollection of the question. Rely on your own. Sergeant Johnson wasn't halfway into the car. At the time of the shot, he was all the way over to the passenger side, securing Mr. Wright's right arm. He had control over Dante Wright. The only time Sergeant Johnson became concerned is when Potter used her taser, said she was going to use her taser. Recall that Officer Lucky testified, and with rapid succession of leading questions, they asked him, well, if you had been in the car, you could have been dragged and hurt. He said, yeah. Well, remember again, that's a hypothetical question. And what the real evidence is that Officer Lucky was standing outside the car. At most, he reached an arm into the car. He tried to grab a hold of Mr. Wright. At one point, he tried to grab the steering wheel or the steering column. He's standing outside of the car, his feet on the ground. He's no more in the car than Potter was. Recall that counsel asked him, as far as you knew, Johnson was in the car. Lucky dutifully agreed with that.
Judge, I object to this. I didn't go into this
The
testimony.
objection is overruled.
For the record, Your Honor.
No.
But during that time, Potter is on the other side of the car from Sergeant Johnson, sometimes behind Officer Lucky. Recall Officer Potter saying she's 5'3". Look at the video. Yeah, her body camera's down here, and her eyes are up here, but she's only as tall as the car. So counsel pointed out, you know, we're talking about the body cam, we're showing you the body cam. Yeah, but her eyes aren't going to be any better perspective of Sergeant Johnson. Just look at the video, see where she lines up with that car. And you heard Dr. Miller talk about hyperfocus. Well, if she had this kind of tunnel vision hyperfocus during this chaotic scene, how did she see Sergeant Johnson's face with this look of terror? The bottom line, factually, is that the opinions of Lucky, Johnson, for that matter, Fleslin, Peterson, Gannon, on which she bases her factual claims, were offered on leading hypotheticals, not the actual facts of the case. This is particularly true of Fleslin, Peterson, Gannon. Fleslin and Peterson only watched brief snippets of the video. Right? They didn't review all of the evidence in the case. Seth Stoughton did. They didn't interview witnesses. They admitted to you all. They were just offering opinions on hypotheticals from Ms. Potter. Mr. Gannon indicated that he watched Ms. Potter's body-worn camera that night and immediately concluded this was an accident. Right or wrong, he believes he was fired for it. But then anyways, at the request of the defense, he then went and watched the squad camera. And that was all. The squad camera's perspective is behind the Buick, the white car, and a little off to the driver's side. It's not a good perspective of Sergeant Johnson's position. The fact is, Gannon didn't even watch Sergeant Johnson's body-worn camera. You have. The facts simply don't support these assertions, but more importantly, these assertions don't even address the proper legal argument you have heard, and you will read in the judge's instructions, that the standard is what a reasonable officer in Officer Potter's position would have known. Not one of those witnesses tried to explain that to you. Not one of them have offered an opinion that it would have been apparent to Officer Potter. Second, I want you to consider the sources of these assertions. Again, the judge has told you in her instructions that when you consider the believability and weight to give to witnesses, consider the interest in the outcome of the case, the witness's interest in the outcome of the case, and the reasonableness in light of other evidence, as well as the relationship of the witness to the parties. These officers were part of her police family. She called it that herself. They worked with her for many years. They relied on her. She relied on them. They were backup for her and vice versa. They liked the things she did. The honor guard, I think we can all like that, right? I mean, that's good stuff. That she did, no doubt about it. The domestic abuse response team, that's good stuff, right? They all spoke highly of her for it. On the other hand, Professor Seth Stoughton is not a part of Officer Potter's police family. He did work as a police officer. He worked as a licensed investigator. And then he went to law school. And since then, he has become an expert in policing. He teaches at a law school. He researches issues related to policing. He publishes extensively. And he speaks to all groups about these issues, not just police groups. Potter kept referring to him as the $95,000 guy or the $93,000 guy. That's not what he charged in this case, right? He testified on the stand. He's so far charged something like $9,000. Yeah, he's an expert witness. He gets paid. He can get paid $95,000. Why use that term? Just going to distract you from the reality. He took the stand anyway, Seth Stoughton, and explained in great detail for you in his own words, not mine, the evidence he believes shows that Potter did not have a reasonable belief that some officer was in danger of death or great bodily harm. He explained the bases for his opinions properly in terms of what a reasonable officer would have known at the scene, the proper legal standard, and he explained it, and he was subject to cross-examination about it. Mr. Imes, on the other hand, who has spent his entire career completely immersed in police organizations, dedicated his life to it, told you that, can't remember if he said 110% or more than that, simply offered a short opinion. Not accepting a fee for his services because that's how important it is, he still was not sure if he had reviewed all of the materials when he wrote his report. He wrote a report that was just over 2 pages in length, and he did not even consider Potter's use of deadly force until after the trial started and the defense brought it up to him through Sergeant Johnson's testimony. Yes, he drove up here. That's how much he cares. But he didn't even know if he had reviewed all the material. Didn't even think about deadly force until it was brought up later. Tim
Beyond the scope of a rebuttal. Mr.
objection is overruled.
I think I already talked a little bit about Mr. Gannon. I would point out here, he too made no attempt to offer a basis for his opinion, certainly not at length. Didn't even watch Sergeant Johnson's body-worn camera video. An interesting thing also, incidentally, that I want to point out, Commander Grunig and then Chief Gannon authorized the BCA to come in and investigate the case. And why is that? To avoid any appearance of bias.
Judge, I
Right.
never mentioned the BCA. It's improper
The
rebuttal.
objection is overruled.
And so they recognize in bringing the BCA in to investigate the potential for bias of fellow officers. You should feel free to consider then that recognition when they nonetheless come in here and testify. But in the end, despite all of that, you can rely on the most important evidence of all, Ms. Potter's own actions and words. Her actions and words before, during, and after she shot Dante right in the chest. There's an old expression that actions speak louder than words. We've all heard that. Here, I think they both speak at the same volume. For her actions and words speak very loudly that she did not believe deadly force was necessary. She clearly said taser over and over. I'll tase you. I'll tase you. Taser, taser, taser. It's consistent with training. Training to provide notice to the subject and other officers. She only pulled the trigger once. You heard testimony that that's what you do with a taser, not a handgun. After she immediately expressed surprise that she had shot him. She immediately said she had pulled the wrong gun. She punctuated that admission with profanity. Pulled the wrong fucking gun. She emphasized. She immediately expressed shock that she had done something so very wrong. Consider the real volume, if you will, of her reaction. She is distraught. She is beside herself. She questions how she could have done this. She collapses to the ground and admits how wrong her conduct was. I'm going to prison and I killed a boy. Is that the reaction of somebody who thought deadly force was really necessary? Also important is what she did not say. She never said, I had to shoot him, or somebody could have gotten hurt, like her fellow officers, her police family. She didn't even take Sergeant Johnson's offer to say that, when Sergeant Johnson said he was trying to drive away with me in the car, which isn't even true. But he offered that to her and she didn't even bite on it. She was so caught up in the recognition of the wrongfulness of her own conduct. Finally, consider her own words to you, here in court, under oath. She admitted to you here that she did not mean to shoot him with the gun. When she was asked about it, she knew deadly force was not necessary. If she didn't believe deadly force was not necessary, how could a reasonable officer in that position believe it? Incidentally, so let me summarize. There simply is no evidence upon which to believe a reasonable officer in Officer Potter's position would have believed that deadly force was necessary at that moment in time. One of the things I want to make sure I point out was mentioned that you're going to have the Glock and the taser back there with you. They will be rendered safe. But keep in mind that the Glock, if you're,
This is not rebuttal.
The objection is overruled.
remember that the Glock has been unloaded, right? That's how one way we're rendering it safe is to take the ammunition, keep that separate. So if you're going to consider the weight, just keep that in mind, please. But you can look at them and see the difference. And we wanted to make sure that you could put hands on it, as Officer Potter had done with her firearm and her taser for many years. All right, I want to talk, I think, somewhat quickly about this argument on causation. That Potter believes Daunte Wright caused his own death is somewhat stunning to me. And let's talk about that for a minute. You know, we have this concept we like to call branding, rebranding, using words to try and change people's perspectives of things. I want you always to think about that in this case as you're evaluating the evidence, using words like the car taking off like a jet, which of course was at the time being operated by somebody Miss Potter had just shot in the chest, blew up his heart, blood's pumping into his chest. Dr. Jackson, I think, said we would call that survivability in seconds to minutes, I think is what he said. But yet we're taking off like a jet. Elena Albrecht-Payton told you he's just sort of like gurgling, gasping by the time they crash. Unfortunately, Daunte Wright's already dead at that point, taking off like a jet. This notion of fighting or struggling with Daunte Wright in the car, I talked about that already. The fact that he was high on marijuana or stoned. Elena Albrecht-Payton told you he wasn't acting like he was under the influence of the marijuana. There's no evidence. You watch the videos. These are used, these terms, to lead fellow officers and maybe you into believing things that aren't really true, to change perceptions of what happened, to rebrand a case as the case about Daunte Wright. And this contention that he caused his own death is factually wrong and legally wrong. It's factually wrong because, very simply, as you saw, Kim Potter shot a bullet into his chest, passed through his chest, blew open the front of his heart, and came right to lodged in his skin. You don't have to, but you can watch the video of the attempts at doing life-saving measures on him, and they put on a dressing that pushes the bullet back in. That's what caused his heart to stop beating and die. To an absurd extent, Potter now attempts to argue that he caused his own death. I want you to consider, if we accept that argument, that he caused his own death, we have to accept that anytime a person does not meticulously follow the commands of a police officer, they can be shot to death. And there would be no consequences.
The objection is overruled.
And there would be no consequences to that officer. That's absurd. It's also contrary to common sense and the law. Every officer that was asked admitted to you that in making arrest, officers have to use reasonable force. I mean, that's why we're here. She didn't use reasonable force. She shot a man. I would have preferred had Daunte Wright followed the commands and not tried to flee, sure. Does that absolve her from liability? Does that allow her to shoot him to death? It does not. Officers still have to use reasonable force in apprehending a person. Now, Mr. Gray talked to you about superseding cause. He read to you the definition. It's plainly in the instruction the court read to you and will give copies of to you. He read it accurately. He's just completely wrong about how it applies. A superseding cause, if you think about it, it makes sense. A superseding cause is a cause that comes after the defendant's acts, that alters the natural sequence of events, and is the sole cause of a result. Ms. Potter's acts came after. For Daunte Wright, for his conduct to be the superseding cause, his conduct has to come after Potter's acts. It's right there in the definition that he read to you. Well, how is it that Officer Potter threatened to use her taser if Daunte Wright hasn't even started fleeing yet? This is a clear diversion, an attempt to blame Daunte Wright for his own death. It's not a superseding cause because the conduct that they claim is a superseding cause started before. It put into motion these events during which Officer Potter decided she would use force and pulled out her gun instead of her taser and shot him. It's not a superseding cause. You can read the instruction, it's plain as day in there. Finally, and I do mean this, I need to address what I contend is a mischaracterization of the law underlying the charges here. This notion of mistake or gun in hand. Dr. Miller got paid a $30,000 flat fee to come in here and tell you what? That people make mistakes. Good for him, I guess. It's not really relevant to the case, right? There's no defensive mistake. It's like a friend of mine says, it's like blaming gravity for falling down a hole, right? Gravity may explain why they went down that hole, but gravity does not explain how they got in the hole in the first place. And gravity doesn't excuse the person's conduct for getting in the hole. If the person gets themselves in the hole, it's not gravity's fault. Right? A mistake is not relevant here. It's not a defense to the charges. The state does not have to prove, moreover, that she knew she had a gun in her hand. If the state was required to prove she had a gun in her hand, that she knew that, we would be talking about an intentional crime. You will see in each instruction the court gives you defining the elements of the charges. That phrase, it is not necessary for the state to prove any intent on the part of the defendant to kill anyone. Right? We don't have to prove that she meant to kill him. This is not an intentional murder. Both counts submitted to you require only that she was aware of the risk, not that she was aware of the gun in her hand. Ms. Potter's counsel argued many times that about what conscious means. Conscious and intentional acts. Well, the easiest way to say this is she wasn't sleepwalking. This wasn't a reflexive action. Her conduct, her conscious and intentional conduct, was drawing, shooting. We don't have to prove that she knew there was a gun in her hand. Those are conscious and intentional acts. You see, the difference between murder and manslaughter is the intent to achieve the final result, right? In murder, the actor intends...
Judge, I object to this. This is way out of rebuttal.
The objection is overruled.
In murder, the actor intends the death. In manslaughter, which is based on recklessness, the person does not intend the final result, the death. Rather, their liability, as I said, is based on recklessness. Their conduct creates a risk that they disregard, and somebody dies. It is her conduct that creates the risk. Her conduct created a risk that she would use the wrong weapon, and her conduct in going to her gun holster, drawing her gun and pointing it and pulling the trigger. These were the voluntary acts, the conscious, intentional acts that she did that created the risk. And what's the risk? What she's been taught, what every officer knows, a gun can kill. What she's been taught over and over, weapons confusion. She's been taught that we have the taser over here. We make it look different. We make it feel different. It has lasers and a light. It has a CID screen in the back so you can see it. She's aware of all that, and she did it. She created a risk by deciding to employ force with a weapon. She knew of all those risks of drawing the wrong weapon, and she did it. She killed Daunte Wright. Even Mr. Gannon admitted that's not what we expect of police officers. We don't have to prove that she knew she had her gun in her hand. That's not the conduct that creates the risk. Right? It certainly is. I think reckless to not acknowledge when you're going to use force and you're thinking about it, to simply disregard all of that and pull the trigger anyway. She was aware of the danger of drawing a gun instead of a taser. She had been trained to avoid it. Things have been put in place to avoid it. The look, the feel, where to wear it. She still used her right hand to pull her gun instead of her left hand to pull the taser. Did not even look to see if it was her taser, and pulled the trigger a foot or two from Daunte Wright's chest, causing his death. She had to know that using her left hand instead of her right hand, or somebody could die, and Daunte Wright died. Thank you for your patience. I hope I haven't worn it out. The state respectfully requests that you find guilt on both charges submitted to you. Thank you.
Okay, jury members, I previously read to you an instruction on evidence of character. There was an error in the instruction. I'm going to read to you the corrected instruction, and this is the instruction that will be in your written instructions that each of you will be given a copy of. In this case, you have heard evidence as to the defendant's general character of being peaceful and law-abiding. You should consider such evidence with all the other evidence in the case in determining whether or not the prosecution has proven the defendant's guilt beyond a reasonable doubt. Now, I told you I would give you some additional instructions prior to you going to deliberate. As I indicated before, each of you will be given a copy of the written instructions. The lawyers and I have determined that these instructions contain all the laws that are necessary for you to know in order to decide this case. I can't give you a trial transcript. No such transcript exists. We count on the jury to rely on its collective memory. If you have a request to have a portion of a witness's testimony read back to you by my court reporter, I will consider the request in consultation with the lawyers, but that request may be denied, in which case you'll be asked to rely on your collective memory. If you submit a question to me about the law or evidence, I will need to consult with the lawyers before deciding whether I can answer the question. Because the lawyers and I may be in other hearings, it may take a significant amount of time to respond to your question. I say this not to discourage you from asking questions, but only to inform you that the asking of a question about the law or evidence is a significant event that takes time to address. Now, you've been allowed to take notes during the trial. You may take those notes with you to the jury room. You should not consider these notes binding or conclusive, whether they are your notes or those of another juror. The note should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear from your own notes or those of another juror. You should not give greater weight to a particular piece of evidence solely because it is referred to in a note taken by a juror. In this case, the state and the defendant have agreed that you will be sent back with a laptop containing all of the video and audio evidence admitted in this case. This is by order of the court. The attorneys have reviewed the laptop to ensure the accuracy of the exhibits on the laptop. You will have a laptop that does not have internet access or other programs or information on it. The only items on the laptop are whatever is needed to access the exhibits that are on the laptop. On the laptop, you will see each exhibit identified by number. You can simply click on the exhibit and it should open on the laptop in an additional monitor that has been provided for you in the deliberation room. If you encounter any difficulty operating the laptop or accessing any exhibit, you may send a note to the deputy who will be outside of your deliberation room. I will then review the note with the attorneys and an IT person and see if the issue can be resolved. If the issue cannot be resolved, we may need to replay the exhibit or exhibits in the traditional manner, with the judge, parties, and jury reconvening in the courtroom and replaying the recordings in open court, and with the jury suspending your deliberations during that time. After we replay the recordings, you will then return to the jury room to continue your deliberations. When you return to the jury room to discuss this case, you must select a jury member to be foreperson. That person will lead your deliberations. Now, we all have feelings, assumptions, perception, fears, and stereotypes about others. Some biases we are aware of and others we may not be fully aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe and disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. You must take the time you need to reflect carefully and thoughtfully about the evidence. Think about why you are making the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender, gender identity, race, religion, or sexual orientation, would you still view them and the evidence in the same way? Listen to one another. Resist and help each other resist any urge to reach a verdict influenced by bias. Each of you have different backgrounds and will be viewing this case in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision making. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. In order for you to return a verdict, whether guilty or not guilty, each juror must agree with the verdict. Your verdict must be unanimous. You should discuss the case with one another and deliberate with a view toward reaching agreement, if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. A single verdict for each count has been prepared for your use. Now, the order in which the guilty and not guilty choices appear on the verdict forms is strictly alphabetical and should not in any way be considered as indicating which choice is the correct choice. And the verdict forms basically say, verdict count 1, we the jury on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021 in Hennepin County, State of Minnesota, find the defendant, and then there's a space to check guilty or not guilty. And the second verdict form is on count 2, we the jury on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021 in Hennepin County, State of Minnesota, find the defendant, and then there's a space for guilty or not guilty. When you have finished your deliberations and have reached a verdict as to the specific count, the foreperson should mark the appropriate choice on the form with an X. The foreperson then must date and sign the verdict form with the foreperson's juror number. When you agree on a verdict, notify the deputy. You will return to the courtroom where your verdict will be received and read out loud in your presence. In arriving at your verdict, the subject of penalty or punishment is not to be discussed or considered by you. This is a matter that lies solely with the court and within the limits prescribed by law. The subject of penalty or punishment must not in any way affect your decision as to whether or not the state has proven the charges beyond a reasonable doubt. Your duty is to both the state and the defendant. The state and the defendant both have the right to expect that you will see that justice is done according to your true conclusions. The responsibility which rests upon you should be borne courageously and without fear or favor. Be fair, act honestly, deliberate without prejudice, bias, or sympathy, and without regard to your personal likes or dislikes. Now, members of the jury, this case is in your hands as judges of the facts. I am certain you realize this case is important and serious and therefore deserves your careful consideration. We will await your verdict. And thank you again, members of the jury, for your attention. In this case, I really appreciate, and I think everyone here appreciates you being here. All right, so now it's time for you to do your job. Oh, excuse me. I am so sorry. I have to dismiss the alternates in this case. It's alternate number 58 and 57. And I'm so sorry that you sat through all the evidence and was unable to deliberate with your fellow jurors. My staff would be happy to let you know what the result is if you wish. So thank you very much. You may gather up your things from the jury waiting room, and your service is both appreciated and over. Thank you. Would the deputy please come forward and be sworn by the clerk?
Do you affirm that you will keep these jurors together, separate from all other persons, and you will not allow anyone to communicate with them or overhear their deliberations, that you will not make any comment to them about the law or facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations. If so, please say, I do.
I do.
All right. Good luck, members of the jury. Okay, counsel. Has defense counsel and the state had a chance to look at the exhibits on the thumb drive?
Yes.
Okay. And is there any objection to the exhibits on the thumb drive?
No.
Could I get a response from the state on the record?
Your Honor, we have reviewed it and we believe they're all accurate.
Okay. And has the defense had an opportunity to take a look at the laptop to ensure that it has nothing on it other than the exhibits and no internet capability?
We have not looked at the laptop yet. We reviewed the exhibits. We can look at the laptop right now and make that determination.
Why don't you do that?
We have something else though, if I could.
Yes.
You know, Your Honor, the purpose of a rebuttal is to briefly and concisely address the key points in a defense argument. This particular rebuttal ran 14 minutes, which is almost as long as Mr. Gray argued. It was pre-typed, pre-outlined, with a design to go that long. It was not a rebuttal, it was a final argument. The amount of time that was used to exactly rebut Mr. Gray's argument was about 10 minutes. We repeatedly objected. I appreciate your overruling objection. We take our objection to your overruling, but it's not a rebuttal. This was a sandbag. He sandbagged us by preparing another final argument, which was unfair. So they've got an hour and 40 minutes of final arguments. And then we also object to the idea that we've advanced that in his dismissal of it, that because she didn't know that she had a gun, she couldn't have been aware that she didn't have a gun. That was Mr. Gray's central argument, and he's saying that is, invalid argument, but the court has permitted specifically that argument to be made. So he's rejecting a defense argument that the court is aware of or was aware of and permitted. And that's not rebuttal either. So we move for a mistrial.
Okay.
Judge, could I be?
Mr. Frank.
Could I just supplement that? State v. Engel requires that you know it's a gun. It's not should have known a gun or a risk. Straight out it says that. In his final argument, his rebuttal final argument, he said you didn't have to know it was a gun. That's one thing that's wrong. The other thing is that he says that the superseding cause is in the middle of some person's negligence. Well, that's not accurate either. A superseding cause, our client was using an authorized use of force, and the superseding cause, while she was doing it, which they claim was illegal, that she was illegally using a taser or a gun, and that superseding cause came while she was doing that, and they say, no, that's not the law. Well, it is the law. And that's another reason for a mistrial. Clearly, they said that you have this superseding causes in the middle of our client's, I don't know what, risk, whatever it was, but that's not the case. Thank you.
Did you want to respond, Mr. Frank?
Sure, Your Honor, I do. First of all, I guess didn't know I would be criticized for being prepared. I think the arguments were easily foreseeable, and I did in fact rebut Mr. Gray's arguments. If you recall him telling the jury, here are the bases upon which I think you can quit him. Didn't cause, right, so I addressed causation. She had a right to use deadly force, so I addressed her right to use deadly force. The statutes, conscious, has to be aware of it, so I addressed that. And I think the other thing is mistake, and I addressed that. My entire rebuttal argument was made in response to the very points that Mr. Gray made in his defense argument. There is no rule that I'm aware of that says if he says A, all I can say is not A. I am allowed to couch my argument in advocacy. And I don't have to just simply say, no, he was wrong. And that's what I did here. And I'm sorry if they found that more than they wanted to hear. But, Your Honor, as to the superseding cause, I can't help it that they chose to seize on that as something to try and convince the jury exists and it doesn't. I'm allowed to say they're simply wrong about that. I cited the law correctly. It's in their instruction. Mr. Gray even cited it correctly. It's not a superseding clause. It's not a superseding clause because Mr. Wright's conduct didn't come after. That's the legal definition of superseding clause. So was accurate. Your Honor, whether she has to know there is a gun in her hand, I think I was accurate about it. We don't have to prove. The court said, Mr. Gray, you can make that argument. That's the discussions we've had a couple of times. He made that argument. I rebutted that argument. That's what I did there. This was a proper rebuttal, proper in scope, properly limited. Sorry, I don't speak as fast as some people do, but it was a proper rebuttal argument. There's no basis for a mistrial, and it asked the court to deny if that is a motion for a mistrial.
The motion for a mistrial is denied. The state was entitled to argue reasonable inferences arising out of the defense's arguments, and also the definition of superseding causes in the instruction, and the state obviously was entitled to argue that as well. Okay, is there anything else we need to put on the record?
Not from the state, Your Honor.
Okay, why don't you look at the computer, the laptop right now so that I can put on the record that you've had a chance to review it. defense had a chance to look at the playback equipment.
Yes, we have reviewed the computer, we're satisfied.
Okay.
All right. The reason that's important is because the laptop will be provided to. They provided the laptop. It'll be given back to them. It won't be part of the record on appeal, and that's why it's important for the defense to be assured that there's nothing inappropriate on it. Okay. Is there anything else that we need to put on the record? Yes.
Are we expected to stay here till 6 o'clock?
I am going to let the jury deliberate until 6.
Okay, so that means we have to be in the room.
Yes. Okay, anything else? All right, counsel, thank you.